Mr. York.
We have started.
Good morning, everyone. It's good to see your smiling faces this Monday morning. I hope all is well and you enjoyed your weekend. The meeting is called to order at 10:03 a.m. Today is Monday, July the 19th. My name is Shanae Buffington and I am chairing, as you all know, Fairness Subcommittee on the ad hoc Commission for Attorney Discipline. So this is, I believe, our second meeting, and we have one more meeting coming up on August the 24th. As you all know, we are being tasked with coming up solutions for promoting procedural justice, reducing disparate impact, and preventing a future attorney misconduct, and improving the experiences of complaining witnesses and respondents in the attorney discipline process. A few housekeeping rules. Please mute yourselves unless you are speaking. I believe the chat function is enabled. I'm not for sure.
It is disabled.
It is disabled.
We had some issues with it before, but it is disabled.
Okay. We will take lunch today, roughly around 12 p.m. I think our meeting is slated to end at 2 p.m. So we don't have our meeting won't be as long as it's been in the past. So I think we'll take our lunch around 12 and we'll have breaks throughout the day as well. I don't believe I'm meeting anything now. Ms. Chavez, can you please take the roll?
I'll take the roll.
Okay.
Thank you. Michelle Anderson. Do not see. Ray Buenaventura.
Present.
Ruben Duran.
Present.
Sarah Good. Shalon Joseph.
Present.
Jerry Larkin.
Present.
Melanie Lawrence.
Present.
Ed Lear. Judge McGill.
Present.
Steve Moab.
Here.
Ellen Pansky. Sean Salee.
Here.
Martin Winfield. And then Shanae Buffington. We have a quorum.
Thank you, Ms. Uritt. Our public comment, I know last time we had a public comment, we had a letter that was submitted by an attorney, but then he ended up appearing to make a public comment. And I don't think we have public comment this morning, is that correct?
Yes, I don't see any members of the public.
Okay. Should we review the meeting agenda for today, or should we just get started with our charter?
Sure, we can get started with the charter, which tells us what we're going to discuss today. So let me share my screen. Can you see my screen?
Yes.
Okay.
Okay, so the charter is available on the State Bar's website. But the ad hoc commission, the larger commission, has been tasked with evaluating the inventory of changes that have been proposed and implemented as far as the attorney discipline process is concerned. And we're doing this to evaluate the impact on public protection. So what we'll do specifically for this subcommittee, as you all know, is to evaluate the policies, procedures, and processes as it relates to fairness. We are going to, again, be discussing promoting procedural justice, reducing disparate impact, preventing recidivism, and again, improving experiences of complaining witnesses and respondents. So over the course of our last few meetings, we have been delving very deeply into issues that affect our attorney discipline system. Particularly, we've been discussing racial disparities in our discipline system. We've discussed at length reportable action bank matters, which Randy and Dag will present on that shortly. We have discussed complaints closed without discipline and how it affects charging of future subsequent complaints. We have received quite a lot of information, rather, excuse me, about what other states are doing their discipline process, specifically archiving, expungements, what's available on our state bar's website as it relates to attorney charges that have been filed and the outcome of disciplinary matters. We will also have a presentation today regarding discussion on removal of low-level discipline from the state bar's website. Mr. Ewart will give a presentation on that. And then we'll also have a presentation from Ray Buenaventura on expungement of post-conviction discipline. And again, we'll be receiving some information on what other states are doing in that regard. And then we will have a presentation on access to representation. I know at our last meeting, there was some discussion about, whether or not having representation during the disciplinary process, if that's worth it, how it impacts the outcome of certain matters, and whether or not attorneys have $15,000, $20,000 to hire counsel to represent them, when matters such as these arise. So we will be receiving some information from Ms. Chavez. She will be reviewing Professor Robertson's policy options. And then Mr. Ewart will be going into detail regarding self-help materials as it relates to access to representation. And then we will be receiving some information on impact of attorney fees and costs. And then we will also, to close out our meeting, we will be receiving a presentation from Judge McGill on the perception of the State Bar Court's independence. So this meeting, we are, like I said, we're going to be receiving a lot of information. I know it's been kind of overloaded for me specifically, how many presentations we've been having, but we really want to have as much access to information as we can so we can make informed recommendations to the larger ad hoc commission. So our next meeting, I'm anticipating hopefully that we will have recommendations drafted for review and comment. Hopefully we can get the recommendations to the larger subcommittee before our August meeting, just so we're not taking a first look at it in August. Mr. Ewart, I don't know if I'm missing anything. Key questions to keep in mind today for our meeting. And I think this is kind of going to the first bullet point is going to segue into our first presentation on RA bank matters. Should the de minimis monetary threshold change? Second bullet point, should there be changes to allow a cushion in client trust accounts? I know we had some discussion at our last meeting, specifically with Professor Robertson, about attorneys depositing extra monies into their client trust accounts to avoid overdraft fees and things of that nature. I think there was some discussion regarding commingling of funds as well. Third bullet point, should the State Bar destroy complaints without disciplinary action specified for a period of time? And how can the State Bar increase access to representation? And should the State Bar reconsider what discipline is displayed on the website? I know that's a huge topic of discussion. Do perceptions of State Bar Court independence or lack thereof impact perception of discipline system fairness? So again, Judge McGill will present on that later today. Should we get started with RA bank matters? think that is Dag and Randy.
Yeah, I'm going to present, Shanae.
Oh, okay, thank you.
Okay. Hi, everyone. I feel like I'm in the LA office today, and I feel like my internet's a little slow. Can you hear me okay? Okay, thank you. All right, so let's get started. Let's see, I feel like, okay. Yes, okay, so what we're going to do today is just discuss a reportable action bank matters. I'm going to quickly remind everyone of Professor Robertson's recommendations and just remind everyone how the State Bar chose to act upon them or not. And then I'm going to turn it over to Randy DeFrontorum, who's the director of OPC, our Office of Professional Competence, and he's going to discuss Professor Robertson's potential reform 1.2. As you'll see in the next slide, this is actually a reform that we declined to implement, and he is going to give more background information on that particular one. As a reminder, we're interested in our reportable action bank matters because Professor Marcus's report found that among attorneys with common law complaints, Black male attorneys had twice as many reportable action cases than white male attorneys. Okay, so Professor Robertson recommended 4 potential reforms, or rather he identified 4 potential reforms for the State Bar to address the racial disparities in RA bank matters. First, he identified raising the de minimis threshold and number of prior cases before triggering investigation. As we presented in our last meeting, the State Bar staff conducted a research study on this topic, and as a result of the findings, declined to implement this, recommended that we do not implement this finding. That's what we recommended to the Board of Trustees. We also considered potential reform 1.2, which is allow attorneys to deposit funds into client trust accounts as a cushion. Given the results that we saw in the study that led us to decline 1.1, we also declined to implement this as well. With regards to 1.3, revised guidance to encourage reasonable reliance on other professionals and technologies. Professor Robertson has been working with the Office of Professional Competence on exactly this, and they have some ideas on how to revise the client trust accounting handbook, and so they're going to be Randy's going to be presenting that to our Board of Trustees later this week. And then finally, with regards to the bottom, 1.4, develop a turnkey bookkeeping solution. Professor Robertson has been working with staff in the Office of Access and Inclusion, particularly those who deal with IOLTA bank accounts, and they're working with different stakeholders to learn more about that. So that work is ongoing. Okay, so now we're going to move on, and like I said, we invited Randy DeFrontorum, the director of OPC, to come give a little bit more information to the background with regards to 1.2. Hey, Randy, take it away.
Good morning, everyone. Potential reform 1.2 would allow attorneys to deposit funds into the trust account basically as a safety cushion against overdrafts. And the essential issue with potential reform 1.2 is that it would require a change in the law, as the current law of attorney professional responsibility does not permit that specific conduct. Rule of professional conduct 1.15 is the rule in the rules of professional conduct that addresses the safekeeping of client funds and property. Paragraph A provides that all funds received or held by a lawyer or law firm for the benefit of the client or for other persons to whom the lawyer owes a contractual, statutory, or other legal duty, including advances for fees, costs, and expenses, shall be deposited in one or more identifiable bank accounts labeled trust account. Paragraph C goes on to say that funds belonging to the lawyer or the law firm shall not be deposited or otherwise commingled with the funds held in the trust account. Next slide, please. And so the case law and the ethics opinions have interpreted this rule, and they have found expressly that commingling occurs if a lawyer deposits funds into the trust account to serve as a margin or buffer against the risk of overdraft. And it even has gone so far as to say that this is true even if no client is harmed. You have both a discipline case from the Supreme Court as well as ethics opinions. The one other example I gave is Los Angeles County Bar Association, formal opinion 485. The practice of the lawyer depositing funds is somewhat different from what would be considered bank-provided overdraft protection. And that is addressed in an opinion from our own Standing Committee on Professional Responsibility and Conduct, COPRAC, opinion number 2005-169, actually allows for an attorney to arrange with a bank for overdraft protection for a client trust account, but there is a very significant proviso. The overdraft protection that is allowed must compensate exactly for the precise amount that the overdraft exceeds the amount on deposit. If there's any residue, overage, if you will, then that money, which essentially is money that the bank is providing on behalf of the lawyer, so it's lawyer or law firm funds, would constitute commingling. Next screen, please. And so there's an example I wanted to use from a review department case. It's in the matter of Robbins. And I'll just read to you what the court said. Respondent generally dealt with very poor, uneducated clients, whom he often paid a few days before the settlement check cleared. Sometimes he made substantial advances to them before the settlement check came in. These advances came out of his trust account. Respondent himself was unaware of any specific problem with his trust account balance because he had an arrangement with his bank for overdraft protection on the client trust account, and it never returned a check. He had no knowledge of the impropriety of such arrangement or any background knowledge of how trust accounts should be properly handled when he opened his practice. He has since learned the seriousness of the responsibility and has instituted procedures to ensure that his trust account is properly maintained. However, during the lengthy time in question, he simply let his staff oversee payments without his personal supervision. One of the points I made just a few seconds ago was that the courts have found that commingling occurs when you have a margin or other buffer of attorney funds in the trust account, even if no harm comes to a client. I picked the Robbins case. There are many others that address this type of commingling because this particular respondent, it doesn't look like they were necessarily using the trust account to further their own interests. What was described here is an attorney who was probably well-intentioned, representing clients who needed their money sooner than later. Maybe they needed it because they were about to be evicted. Maybe they needed it because the creditors were knocking on the door, but the lawyer made an attempt to get the money dispersed as soon as possible, had an arrangement for overdraft protection. But what effectively occurred was that it masked the problems with his trust account. And so it allowed him to have sort of an out of sight, out of mind view of his trust accounting status of his trust account. And it is something that the court would say that even if no harm comes to the client commingling occurs, I would say with this case, it appears that the policy is so strong that even if an attorney is trying to help a client, this type of commingling is prohibited. Next screen, please. And so just a few observations. I just wanted to give you a quick overview. If you've never called the ethics hotline, then I've just given you a sample of what you would get if you called our ethics hotline and asked this precise question. Ethics hotline doesn't give advice or opinions, but sometimes the authorities are pretty on point. And so if the attorney called the hotline and wanted to know about leaving money in the trust account, depositing money in the trust account, having overdraft protection, then these are the authorities that would make clear that the existing law would say that that would constitute the violation of commingling. And so the requirement to keep a lawyer's funds separate from funds held in a fiduciary capacity is to avoid confusion about whether those funds belong to the lawyer or to the client or somebody else. And so if you look at the rule that the board has adopted, the court has approved, the record keeping standards that the court has allowed the board to adopt, they talk about having to label funds and property of others, to place them in a place of safekeeping, to properly keep records and accounting of them. And that's all for purposes of ensuring that the ownership of funds or property held in a fiduciary capacity for a client is completely clear from any property or funds of the lawyer. In a bank account, that's achieved through record keeping. The consequence is that if the fund ownership is unclear, then the client funds are put at risk of being confused or mistaken to be the funds of the lawyer. And one of the downsides of that is that if a lawyer's creditor were to come against the lawyer and it was believed that lawyer funds were being held in a client trust account, then the client's funds could be put at risk of creditor claims. Another example would be if the lawyer were involved in a criminal proceeding, was being investigated for criminal violations, and there were claims by the prosecutor that the lawyer had funds that were the instrumentalities or the fruits of their criminal activity, and sought to freeze or seek forfeiture of those funds. If funds of the lawyer were kept in the client trust account, again, confusing the title or ownership of those funds, then the clients would be harmed by the fact that lawyer funds were intermingled, commingled with the client's funds. Next screen, please. So while it is true that you can use accounting, the other thing that was noted in the Robbins case from the review department is that that is certainly something that lawyers ought to do. They should aspire to it. It should be something that they take seriously. But the particular respondent in the Robbins case was described as someone who for many years simply did not properly supervise and allowed the staff to oversee. And so the practice of putting money into the trust account, the practice of using overdraft protection, in one sense, I guess I call it an enabler for those lawyers who aren't inclined in the first instance to take trust accounting responsibilities seriously and to engage in lackadaisical supervision or poor accounting practices. Being able to rely on overdraft protection or just depositing a buffer might actually promote client harm by causing lawyers to be unaware. And so this particular rule falls into the category of a prophylactic standard. It's one that's intended to keep lawyers out of a significant danger zone. And so that is essentially the state of state with regards to the existing professional responsibility law on a lawyer considering placing funds into a client trust account in order to serve as a buffer or hedge against overdrafts. It is prohibited as a form of commingling, and commingling is closely related to the similar but different violation of misappropriation, which is essentially theft, and that can occur intentionally, that can occur through gross negligence, but it really is also a potential slippery slope, I'm afraid. But all that said, the last point on the slide is that the California Supreme Court can change this rule. They have primary plenary authority over the regulation of the practice of law. They can, upon recommendation of a board adopted change, completely modify or eliminate this standard. The burden would be on the state bar, however, to make a persuasive case for that. Why should this protective zone created through this prohibition be changed? Again, under existing law, you can have a form of overdraft protection. It just has to be one that doesn't give rise to a residue of lawyer funds sitting in the trust account that would violate the standard of commingling. And that's all I have on this topic. Happy to answer any questions.
Thank
So,
you, Randy. Oh, Judge McGill.
so just to add one thing to Randy's presentation. So these cases sometimes that come in the state bar court system present a bit of a challenge for us as judges. Of course, wherever we find culpability, and as Randy discussed, culpability comes up pretty easily, even where attorneys have not engaged in any harmful conduct related to their clients. But the standards are, I was trying to look them up real quickly just to have them here while I talk about them. But one of them that is set is that if there's any commingling, the presumed sanction for discipline is 90 days. We have in the past, there's a recent case in Ray Martin that came out last year where the respondent was able to demonstrate there was no harm because he never kept client funds in the CTA. He was using the CTA as his own personal checking account, but because there was absolutely no commingling per se, even though he did violate the rule, we looked at the disciplinary standards and decided to go below the 90-day minimum and to issue a public approval. So in the midst of all this with the case law, you also have to take in consideration the disciplinary standards that apply for the violation and also how the court uses aggravation and mitigation evidence in making its final recommendation. I'll be talking about a little bit more on that point later this afternoon.
Thank you, Judge McGill. Believe Leah will speak next, and then Mr. Larkin.
Randy, I was just wondering if you could play out a little further. If the rule was changed and commingling was allowed, how do you think it could be constructed to protect against some of the inherent risks that you identified?
So one of the things that's already permitted is that a lawyer may place lawyer funds into the client trust account that are reasonably related to bank charges. And so at present, the COPRAC opinion that's out there, some view it as being rather stringent, very strict, because it's one for one, dollar for dollar, penny for penny replacement of the overdrafted amount. What you could envision is a rule change that actually allows more common forms of overdraft protection that might have some standing evergreen amount that the attorney contracts for that would in fact result in an overage or a residue, if you will, of lawyer funds in the client trust account. But as long as that amount was not excessive, and that there might be perhaps some additional record keeping standards on top of it, that you could be allowed to use that form of overdraft protection. And so what would otherwise be something difficult to get perhaps from some banks, or not exactly what the lawyers are looking for as coverage for overdraft, you might have something more amenable for lawyers to use in practice, with some restrictions, again, perhaps through the rule, black letter of the rule itself, or perhaps through board adopted standards. Since Rule 115 does allow the board to adopt record keeping standards, you could have something that allows for an amount that has a reasonable relation to overdraft protection, as opposed to something, which would be some ad hoc lawyer depositing or funds at random times and random amounts, or lawyers just choosing to leave amounts of their earned fees in the trust account. Those things I think it would be very difficult to make a case to allow a lawyer to undermine the integrity of the trust account to the point where that separateness is lost. But if you had a rule change that allowed for a less strict form of overdraft, that might be something to consider. Again, I'm not being an advocate for that, but I'm just trying to describe something that might be feasible. And I invite our disciplined staff who are more knowledgeable about the way these things come up to offer their observations about that type of change in the rule.
Thanks, Randy.
Mr. Larkin.
I just want to echo most of what Randy's comments were. This is really something that I believe is consistent across the country. There are variations, of course, in the rules related to handling trust accounts. Remember that as we handle funds of clients and third parties, we're fiduciaries. Guessing you have sub-accounting requirements so that at any given time a lawyer should be able to true all that up and know they have the right amount of money in the account. I'm sure there's some variation across the states about, whether there is a cushion amount. I didn't see anything in the ABA annotated model rules. I just looked at them. We don't allow it, but I think generally speaking, the concerns that Randy mentioned are ones that I hear all the time. It's a slippery slope, and I think it's real. I think that it might be more effective for this committee to focus on not so much the record keeping rules, but some of the other ideas that were being discussed. I would not initially favor allowing for that cushion, although costs of account are allowed as a separate lawyer money, but maintained usually in a separate sub account and a modest amount of money. I think the question of a threshold for triggering a bank report or for acting on a bank report is something internal to the bar, and that could be a different way to handle it, or even just the guidance that Randy's team provides to lawyers who call up, or the guidance that might be provided and has been enhanced when a bank makes a report and that report is sent out to the lawyer. There are lots of ways to educate lawyers on this important topic and that way reduce real disparate impact as opposed to just volume of cases. Those are just my comments.
Thank you, Mr. Larkin. I was, Randy, as you were going through your presentation, I was thinking to myself, if possibly, this change is implemented, if we can persuade the State Bar Supreme Court, how will this impact our office of Chief Trial Counsel, do you think? Like, I'm trying to think, I don't know, potentially will more work, I don't know, be increased? If, we have attorneys trying to figure out, what amounts are the lawyer deposited as opposed to what amounts were deposited from a client. Like, I'm just trying to think, how will it impact staff at the bar office?
I think that's something that maybe Steve or Millie can address, but let me just make one observation that in the Robbins case, no NSF was issued because of the lawyer's arrangement for overdraft. And so one of the things that could be considered is that even if lawyers are allowed to have a form of overdraft protection, that they might have a self-reporting obligation when overdraft is triggered. And I think that would force the attorney not to let the overdraft protection, again, operate in such a way that deficiencies or irregularities in the trust account are out of sight, out of mind. And so if the lawyer, there's a number of self-reporting obligations in the State Bar Act, 66680, laundry list of them, would it be hard to add another self-reporting responsibility or add it to the rule 1.15 that if trust account overdraft protection is allowed, when that overdraft protection is triggered, that the lawyer has to self-report. Now, that would add another reporting item into the pipeline that the State Bar staff on the discipline side would have to look at. But I think it's a quid pro quo for allowing the practice because, again, the risk is that if you have overdraft protection, then NSFs will not be issued by the bank and the lawyer might just be sort of on cruise control.
Thank you, Randy. Mr. Salik?
Yeah, so I agree with what seems to be the growing consensus that we shouldn't allow commingling per se, and that overdraft protection is a better way to go. We might look at liberalizing that a little bit, as Randy has suggested. I mean, my view on that has always been that it's better for the clients to have the checks not bounce, right? And so to have the, make sure the check clears, and then the lawyer needs to deal with the bookkeeping. But the one thing I would suggest, and Randy, you've implicitly answered my question, which is whether banks have to report the triggering of overdraft protection to the bar, just as they would if there were insufficient funds check presented. So I think if they don't have to report that, we should take steps to make sure that the bank, it's fine to impose self-reporting on the lawyer, but I think we want to be sure that the bank reports to the bar every instance in which overdraft protection is triggered, because that indicates a problem with trust account management. And we want to try to prevent these problems as much as we can. Self-reporting by a lawyer who's either just sort of disorganized or dishonest is something that's really only going to come up after serious problems have already occurred. So those are my thoughts. That might require the bank is, if the statute doesn't already require the bank to report when overdraft protection is triggered, then that's probably going to require a statutory change, and that's something we should look into.
Thank you. Melanie, I see that your hand is raised.
Yeah, thanks. I also concur with a lot of the comments made. You know, I think that the idea about self-reporting overdrafts is interesting, but I worry a little bit about adding more rules and also self-reporting requirements that we really have no potential ability to enforce. If the only thing that brings it to our attention is the self-report, we're not going to know in the absence of the self-report. I guess, you know, we can do things like allowing, you know, cushions or adding self-reports, et cetera. But frankly, to me, the biggest issue really is just education. Anybody can open a client trust account and not have any education around the requirements of it, all of the special rules required of it. And a lot of times I do think that things happen just because of a carelessness or lack of information. And that if people just had some fundamental requirements to begin with, and maybe some regular refresher MCLEs, et cetera, if you have a client trust account, I think that would go a long way to addressing some of these issues.
Thank you, Melanie. Judge McGill?
Yeah, I also have some concerns about the cushion, because then we'd have to look at what is an acceptable cushion, what is a non-acceptable cushion. You know, the case law is pretty clear, like I've talked about a few minutes ago. I mean, it's very strict. And I think if I recall correctly from Melanie or Steve, when they did their presentation some time ago, you know, not every NSF charge that they become aware of becomes a disciplinable offense. I assume there's pointing to education, warning letters, advice letters, encouragement to go to the client trust accounting school, those kind of things. If it's only just the overdraft issue, did I recall that correctly, Melanie and Steve?
Yes, that's right. In fact, the majority of them do not move forward for investigation.
Thank you. Any other comments or questions from other members of our group about whether we want to possibly pursue recommending attorneys depositing cushion amounts into their client trust accounts? Are we kind of all on the same page that this is something that we may not want to recommend at this time? Oh, I'm sorry, Steve and Moat, and then Mr. Lear.
Great, thank you. I agree that I'm not sure that it makes sense to allow commingling. I guess my question is, if we're going to go the route of having a more vigorous overdraft protection that we're going to allow, but then also follow the path of reporting that overdraft when that occurs. I assume that the theory is that we're going to look at OCTC is going to look at that as a potential trust accounting violation, and that we would then be saying, okay, please explain, et cetera. So I think that the outcome of that would then be that we are ensuring that the client gets paid, the person to whom the check was originally issued, and in some ways protecting the client there, but we are not necessarily impacting the fairness issue that is the root cause of what this committee is looking at. And so I guess I would just point that out. I think it, in many ways, does protect the client, which I think is great. But if we're still asking them to then respond on the potential overdraft, then there's that root issue that we're not addressing.
Thank you, Mr. Lear, and then Mr. Salee, and then
Thank
Mr. Larkin. I'll have to take notes here.
Thank you. I apologize for being late, so I hope I'm not covering anything you've already covered, but I haven't really heard much of a defense perspective, so I thought I'd chime in. One, I don't think I know it doesn't benefit lawyers to add an additional reporting requirement, and so I take the position that let's not pile on. Let's really think that one through. And so I don't like that. There are already plenty of reporting requirements. Melanie and I agree that at least one way to handle this issue with respect to any kind of client trust accounting and or accounting issues is more education. And I for one, really coming around on a mandatory type of education component for client trust accounting. And at this point, I don't understand it to have been mandatory. I tell every client of mine and any lawyer that'll listen to me that going to either ethics school or client trust accounting school as provided by the bar would be something that they should do, and that I'd like every attorney on the planet to do. And so I'd like to focus more on that rather than creating more opportunities for failure, and more specifically failure in the client trust accounting context, because as you all appreciate, those are strict liability violations. And so they carry with them significant consequence. I also note that I've handled many matters where there have been overdrafts and the amounts have been somewhat de minimis, and we are able to show that it was a mistake, an inadvertent mistake, and that the bar has treated that appropriately. So it's either resulted, many times it results in a warning letter, which is, I think, the appropriate way to do it. And that's something that is then on record for that particular attorney. The attorney's been warned, and I understand and appreciate that if it happens again, at least close in time, that the attorney's been warned, and that there may be a different consequence next time, because that attorney was given a break, was warned, was told to not let it happen again. And if it does happen again, then you're going to have to suffer. So those are my 2 cents, but I'm certainly not in favor of adding an additional a reporting requirement that creates an opportunity to fail. Thank you.
Thank you, Mr. Salee, and then Mr. Larkin.
Yeah, thanks. So I wanted to follow up on Steve's comment about fairness, because we are the Fairness Subcommittee after all, and his point is well taken. I never really focused on this before, but the board is also actively thinking about trust account regulation. And I never focused on the difference between smaller trust accounts and larger ones. And there is a fairness issue there, right? So if you have a small trust account where you're dealing with relatively small amounts of money, or you only have funds in there for a few clients, the most minor bookkeeping error can result in a return check. And so that, as opposed to a larger firm or a firm that deals with many clients, right, there's almost always going to be enough money sloshing around in that account so that a $5 or $100 error in bookkeeping is not going to result in a return check, and presumably the firm catches that eventually. But I think at the end of the day, we have to be sure we're taking every step we can to protect the client funds. And the mission of the bar is to protect the public. It's not to protect attorneys. And, we have a major systemic problem with a few attorneys who take money from clients, who steal the money. And we have a client security fund that is intended to reimburse those clients, but it's way underfunded. We're trying to fix that also, but it takes a long time for clients to get back their funds, and there's a cap on how much they can get. So main thing I want to speak to is the board is looking at measures that will deal with different ways of regulating the larger trust accounts. And so I think in my mind, that's the way to address the fairness issue, is to make sure that the large trust accounts are monitored and with the same degree of strictness as a small trust account is, by virtue of the reporting system, the bank reporting system that's already in place.
Thank you. Mr. Larkin?
I just also wanted to build on Steve's comments, which I think are really appropriate and direct us properly. And on the fairness side, I agree. I was interested in Sean's comment and Ed's comments too. I think the coincidental or correlation here is between a number of touches that the bar has, investigations or reports, and outcomes on discipline. And I know we have talked about it, and we'll talk about it further. I think how the bar, that correlation it's not causal necessarily, but it certainly looks like it might be. I think there are other ways to address that fairness aspect than the cushion. So I even Ed recognizes this a public protection issue. He represents the respondents, and I think it's very common. I think it's true in California too, that mistakes don't lead to discipline. It's something different than that. And so, so we don't know what it is that underpins the correlation. And there are lots of things we talked about, and I think that's a better place to spend time than changing the rule to provide for a cushion.
Thank you, Mr. Larkin. There's no further comments. Mr. Yord, are we going on to our next presentation, complaints closed without discipline, or should we put the screen back up with the questions for today to kind of keep in mind?
I think we can do it now while it's fresh. We can also bring it up at the end, but if we could get some clarity, if there are areas where we would like to do further research, because it sounds like the cushion in the comments is not necessarily something that the subcommittee is supporting from what I've heard so far. There might be some in terms of protecting the public, allowing for a little more leniency in the overdraft piece, but I would just ask the subcommittee now to kind of, is there an area where you would like us to bring back more, do a deeper dive and make some recommendations on this? Do we have consensus? Because those are the areas that I've heard. And I also heard about the mandatory MCLE training for anyone who has a client trust account. Is that a recommendation that is supported by the subcommittee? Those are kind of the areas that I've heard talked about, but I'm hoping to get a little more definition on those three areas.
Thank you, Mr. Ewart. Maybe Melanie can kind of, for me, kind of refresh if, so the bank reports NSF activity, kind of what happens thereafter. I know the attorney is, I'm assuming, notified. And at that point, is the attorney, what happens thereafter? I know it's kind of depending on the facts of the case, but is the attorney required to attend client trust accounting school, or what happens thereafter? Trying to figure out if some of these measures are already in place.
So at the intake level, when we get a bank reportable, we almost always reach out to the respondent attorney to request information as to why there was an NSF check. And that informs how we handle it going forward. In frankly, the majority of cases where it appears to be a mistake, or for example, someone, a common explanation might be that they issued the payment to the client prior to the settlement check clearing the bank. But in the end, the client gets the money, the settlement check is deposited, et cetera. Then they might be issued a warning letter, for example, or a resource letter. So many cases are either outright closed, and certainly if it's a strict mistake, it's outright closed. If it's a de minimis and there are no other, there's not a history of bank RAs, or there aren't other cases and investigations, in those cases, we don't actually even reach out to the respondent attorney. But there are a number of times when at the intake level, we are issuing a resource letter or a warning letter. And that gives them all kinds of information. We actually, in conjunction with the Robertson recommendations, did beef up those letters. So they have a number of different resources, including Client Trust Account School, for example. It's not requiring them to go, but it's certainly suggesting that they go. So that's how the majority of those complaints are handled.
Thank you, Melanie. Mr. Duran, and then Leah.
Thank you, Madam Chair. As we're discussing this, it seems to me that awareness and education are extremely important for preventative measures here. And I'm not sure that I'm clear what sort of education lawyers are getting at various stages in their career. For example, I don't know if the law schools typically touch on an administrative yet important issue like this. I know that new lawyers have to go mandatory ethics and other training, and I'm not either I've forgotten or I'm not clear on whether there's a component that touches on this particular rule in these circumstances. So maybe staff can address that at a later point. I'm also curious as to whether the banks themselves that are opening and administering these accounts are open to assisting us in educating lawyers about the basic rules and maybe some effective prevention tools. And then finally, to the extent that the bar is going to reach out to our licensees as a whole, we should also consider, I think, reaching out through the affinity bars in the state, just to highlight this as an important issue for preventative purposes again. That's it.
Thank you. Makes sense. Leah?
I just wanted to note that this is a really timely conversation because the board will be considering an agenda item later this week. And Randy, feel free to speak to this, around the preventative education modules, which include both an e-learning component and self-assessment components. And the first self-assessment module is in fact on client trust accounting. My understanding is the recommendation for the entirety of the program is that it be voluntary. Attorneys are incentivized to participate through the receipt of MCLE credits. But at one point, there was some discussion, and Steve, jump in, or anyone else who can bring us up to date on this, about making a course on client trust accounting in particular mandatory for attorneys who transitioned into a solo practitioner status, or for attorneys who were in a solo practitioner status. So I bring this up to say the board is going to be considering something directly on point later this week. And we might want to discuss a little bit further whether or not to consider making the self-assessment module mandatory, at least for some attorneys, and not necessarily ones who've been involved in the discipline system, but again, who are in the practice type solo practitioner status specifically, where client trust accounting might be most relevant. Randy, I see your hand up, so maybe you can correct anything I've said inaccurately.
No, I think you covered it well. The one thing about the self-assessment program is that we're starting with 10 topics for 10 modules. The first one is going to be client trust accounting. We're actively looking into it. But this multi-year plan involves reviewing the self-assessment data collected on each of these modules once they've been out in the wild for a while. So say 6 months after our first client trust accounting module is issued, we would study, a staff working group would study the self-assessment data collected, and sort of from a data-driven perspective, if the self-assessment module and the survey questions asked revealed certain weaknesses for certain populations, then there would be a basis for designing what specific content and for whom a course might be made mandatory. And so we do have some thoughts, and to our OCTCS thoughts from their experience, OPC as well. We did a client trust accounting survey 2015, and 1,094 attorneys gave us feedback on client trust account practice. So we have a bit of an idea of what might be areas to target for mandatory training. But one of the goals of starting with client trust accounting for the very first self-assessment is to really zero in on that, so that it is a data-driven decision that if we make a client trust accounting course mandatory, then we've looked at the data on, say, the difference between solos and small firm practitioners, how they answered the self-assessment versus how others answer that. And just in regards to education in general, the primary vehicle for education on client trust accounting is the State Bar's Handbook on Client Trust Accounting that's been out for many years, ever since the board was first authorized to adopt record-keeping standards. And at the very beginning of that book, on page 2, 4 paragraphs down at the start, and I quote, "And don't think if you keep enough of your own money in the client trust bank account that everything's all right. Not only doesn't that satisfy your professional responsibility to your clients, it constitutes an additional violation known as commingling. In short, the only adequate way to fulfill your fiduciary responsibility to your clients is to keep track of, and at all times, how much of their money you have in your client trust bank account." And so no one is obscuring or trying to hide the ball with regard to this specific topic in commingling. It is known, it is a known issue that lawyers believe that maybe this is the way to go. And so because the law is what it is, the guidance offered by the State Bar makes that clear.
Thank you, Randy. Mr. Moat?
Thank you. Yeah, I just wanted to respond to Leah's comment. Leah is correct. This is something that we have been working on since I got to the bar in 2017, and that is outreach to lawyers who transition careers, for example, from a government agency into private practice. Just by way of my own experience, I was a criminal prosecutor for 20 years before I came to the bar. I have spent my entire career in government practice. I've never had a client trust account and have had no need to, but if I went out and hung a shingle tomorrow, and I would need to have that experience, I would need to have some training. So what we had talked about was first implementing the self-assessment type of thing that Randy has been talking about, and that's been in development for some time, and we're getting that to the finish line. We've also been working on the technology side to be able to track where people, the practice sectors and practice size. So if they leave a large civil firm and go into a solo or small firm, or they leave a government practice and go into a solo or small firm practice, that they would then be, they'd get a letter, frankly, from OCTC that would say, "Congratulations on your transition. We wish you the best of luck. Here are some resources." Now, to Leah's point, the referral to the self-assessment for client trust accounting would not be mandatory because OCTC didn't think that that was something that we could mandate. But if this committee is interested in making that recommendation to the board to have that be mandatory, then I think that's fine. But the intent was to reach out, to send that letter, to offer them our best and our support, and some resources to do that, which would include client trust accounting education.
Thank you. Ms. Joseph, I see that you have your hand up.
Yes, thank you. Good morning. Steve, to your point, in the resources is the handbook that Randy just mentioned. Is there an electronic version of that that could be sent to individuals who are transitioning so that they have that handbook right when they're starting the process, and that we're being proactive in sending that to them as one of the materials?
I saw Randy unmute, so I'll let him respond because I think that's why he unmuted, but I'm happy to come up afterwards and give you my thoughts if necessary.
Sure, thanks. So the Handbook on Client Trust Accounting used to be an actual physical book that we sold for many years, softbound book. It included sample ledgers, forms, and journals, detailed examples of how to conduct a reconciliation. It transitioned many years ago from being a physical book to an online PDF, which is available in sort of 2 access points at the State Bar website. You can get it through Ethics Resources. You can also get it through Client Trust Accounting. And any attorney can avail themselves of the full content of the Client Trust Accounting Handbook online at the State Bar website. It is available as a downloadable PDF.
Thank you. I think Ms. Joseph's comment was, when attorneys are transitioning, as Leah had stated previously, if they're solo or transitioning to solo, becoming a solo practitioner, can the State Bar, we have enough resources to circulate that PDF CTA handbook to attorneys? That's something that that's something that can be done, or possibly more work on the State Bar? Or
when we reach out to those attorneys that have transitioned, the plan is to include a link to that in that letter. So yeah, we have not started sending that yet, although I am getting daily emails of people who have transitioned or changed their practice sector or practice size. But we're developing the way to then have those emails go out automatically so that with those resources and that will be included.
thank you. Okay, I don't see any more hands. We were supposed to spend 30 minutes on this, and we spent quite some time on this. So it seems to me, or appears to me, that the group or subcommittee is leaning more toward awareness, education, outreach to prevent an NSF activity and to decrease RA bank reporting. Not necessarily, we're not going to recommend at this time that attorneys deposit extra funds into their CTAs to allow for a cushion. Is that kind of where we are as a group? Okay, no comment. So any further follow-up on this issue? Okay. But before we go on, I think Ms. Chavez, you are going to present on complaints closed without discipline. Am I correct?
Yes, I'm going to introduce the topic.
Okay. But before we jump to that, Justin, on our slide, I think the first question was, does this group want to reconsider raising the de minimis threshold? I don't think we've specifically talked about that. Is it appropriate to talk about that now, or should we wait later on? I really kind of don't see that covered in our agenda.
We can discuss that now. Or,
okay. And we're going to be behind, but.
Well, there is some flexibility towards the later part of the schedule when I talk about costs. So I think this was a good discussion, and I'll make sure that we get back on track. The de minimis, it was put to the committee if that's something that they would like to revisit, but I don't know that there is support. From what I'm getting from the previous discussion, that there definitely seems to be support towards the training, whether it be mandatory or targeted outreach, which is what I took away from it. But I think in the interest of time, we can move forward to the next piece.
Okay. Let me get started. All right. Okay, all right, so, oops. Okay, so as a reminder, one of the topics we're looking at are how to deal with cases that are closed without discipline. And the reason why we're interested in this topic is because Professor Farkas's research found that almost half of Black male attorneys had at least one complaint filed against them, and 12% had 10 or more complaints. So first, I'm going to give an overview of Professor Roberts' potential reforms, and in particular, how the State Bar, what State Bar decided to do with regards to each of them. Then I'll do a little reminder on the research we've learned from how other states deal with closed complaints. And then I'm going to turn it over to Melanie and Steve to give a little bit more information on Professor Robertson's potential reform 2.2. This is actually a reform that we did implement. And then we've asked Melanie and Steve to just take us down into a little bit more on how it's actually playing out. So just as a reminder, these are the three potential reforms that Professor Robertson recommended. First, he said, consider expunging complaints closed without discipline after 5 years. And we declined to implement that one. He also recommended 2.2, which is another option, is to just simply archive all complaints closed without discipline. And we actually partially implemented that one, and I will describe that in a moment. And then the third one is to do a potential reform 2.3, which is to develop a proactive non-disciplinary system to support attorneys at higher risk of future complaints. And this is something that is a lot more of a long-term objective because it involves doing an in-depth analysis of all the complaints closed without discipline, and in particular, understanding the complaints that are closed without discipline. What were those actual allegations at a more granular detail than we have available right now? And so that work is ongoing. So let me describe the 2.2, because that's going to lead up to what Melanie and Steve are going to talk about. What State Bar ended up doing was kind of like a hybrid between 2.1 and 2.2, and this was at the direction of the Board of Trustees last July. And in particular, so when Professor Robertson presented his report in July of 2020 to the board, the board adopted the following resolution: that the OCTC should develop to implement an interim reform that prior closed complaints more than 5 years old should not ordinarily be considered in evaluating and investigating a new complaint. And then, so it's kind of like, so remember the 2.1 said expunge after 5 years. The second one was just archive all complaints. And this is kind of like a hybrid. It's saying archive after 5 years. And so the resolution also identified who will have exceptions to this rule. And it says that exceptions are permitted based on written showing to an attorney at the level of assistant chief trial counsel or higher. So that again, so identified under which exceptions this won't apply. And then also identified which complaints are really excluded from this. So prior closed complaints for purposes of this resolution do not include those resolved with a warning letter, directional letter, resource letter, or agreement in lieu of discipline. So before I turn it over to Melanie and Steve to just take us down into how this is playing out on the ground, I just want to remind everyone what we've learned about what other states do. Sorry, before I do that, let me just share that, just a reminder, when the Board of Trustees implemented this policy, or rather passed this resolution, the first thing Interim Chief Trial Counsel Lawrence did was she issued a directive to all the staff not to consider complaints that were closed more than 5 years ago without exceptions, of course with the exceptions. And then after that, staff identified approximately 400,000 cases that were closed that were more than 5 years old, and worked with the vendor who works with our Odyssey database to shield them from view, and that was implemented in November. And then also staff created this automated process so that as a closed complaint hits that 5-year mark, it's automatically archived. So staff do not have to do anything manually. Okay, so now I'm going to just remind everyone what other states do. So like I said, we did this brief survey to all states asking them for how they implement various reforms that we've considered or not considered. And we learned, for example, with regards to close complaints, that there's actually 7 jurisdictions that have rules for expungence of cases closed without discipline. Here they are. So the second column describes the cases that are eligible for being expunged, and then after how many years, which is on the right. So here are the 7 jurisdictions right here. We did reach out to Illinois to learn more about their particular policy, and Jerry Larkin's here, of course, to answer any questions about that. But what we learned is that this was a Supreme Court rule, and it was adopted in the late 1990s, early 2000s as a result of a Blue Ribbon Commission study. And in particular, we learned that the following is expunged: investigative paper files and related electronic case and documents. Management records are expunged, destroyed. No record exists after expungement. And when? After 3 years that a complaint is closed or dismissed. So with regards to the states that do what we do, which is just to shield line staff from closed complaints, there's actually 3 states that do what we do: North Carolina, Florida, and New Mexico. And these are the different cases that this applies to. And on the right is a column that describes the different years. So North Carolina does a 3 years, Florida does a 5 years, just like the State Bar. New Mexico waits for complaints to reach 10 years. Okay, so now I'm going to turn it over to Melanie and Steve to take us a little bit deeper into our policy that we adopted. Go ahead, Melanie.
Great. Thank you, Lisa. So as Lisa mentioned, we got the resolution from the board. Melanie immediately issued the directives to the office, and we set about trying to implement that resolution. And so based on that resolution, we discussed with the chair and vice chair of the Regulation and Discipline Committee several categories of cases that needed a little bit further consideration, or at least clarification as to whether they should be archived. And the consensus was to archive closed cases of all types and origins in which the complaint was filed more than 5 years ago, with the following exceptions. Number 1, cases that resulted in either discipline, an agreement in lieu of discipline, issuance of the warning letter, directional letter, or resource letter, as Lisa said was in the resolution. Where the respondent has a pending case in investigation, pre-filing, or state bar court. For example, if somebody has that pending case in investigation, the cases that may age out to 5 years while that initial case is open, some other case is open, would not be archived until the other case was closed. And we did that more as a practical matter for staff, because they would be looking at a case in the case management system, or could be looking at a case in the case management system, and it would be there one day and gone the next. And it seemed like it would create more confusion at that point. And the other piece was where the respondent was disbarred or resigned. And that's because we felt like those cases would be needed when somebody comes back to be readmitted or reinstated. That would be part of that investigation as to whether that reinstatement is appropriate or not. It was also decided that for cases that were reopened after initially being closed, the 5 years would be calculated from the reopen date, not from the initial opening date. So it may be sometime later that 5 years would go. As Lisa mentioned, we did identify 400,000, I think initially it was more than that, complaints that satisfied that criteria. We worked with Tyler Technologies, who is the creator of our case management system, and they developed a programming routine that added a security group to the list of cases that we gave them, those 400,000. And that security group in the system then means that the vast majority of our staff cannot access or even see these cases. So they don't even know that they exist when they run a search for that respondent. It doesn't show up as, here's this case, but you can't see it. It doesn't show up at all if they are within that security group. We have also developed an automated system for archiving complaints, working with both Oriya and IT, that meet the parameters I just talked about, meaning as a case rolls into that 5-year mark, it will automatically be archived and have that security group added to the case. So there are 2 methods of accessing an archived complaint, and those are based on the nature of the need. The first is if somebody needs or feels like they need information about an archived complaint, then they would submit a written showing to an ACTC or above. That's an assistant chief trial counsel or higher that can authorize the release of that information. And those are very limited circumstances. That is when, for example, they would be requesting that evidence to prove that to help prove as evidence that a person committed a crime, civil wrong, or other act that is relevant to a case that they're currently prosecuting. You can think of this as the discipline analogy to 1101B character evidence. And it's fairly limited, just as 1101B is at times as well. It can also be used to rebut evidence that is adduced by a respondent at trial. Again, fairly narrow and doesn't apply to very many cases. So the other time, the other occurrence where we would allow people to look at these archived cases, it's not so much that we would unarchive or add them to be able to see it. It's really based on a role, and that is that people who receive emails and regular mail from complaining witnesses or other people, we often, this may surprise you, but we often get emails and additional mail is what we refer to it, from people more than 5 years after their case has been closed, after the case has been closed. So the CW will send follow-up. We get them 5, 10, or even longer years after that case has been closed. So we need to look at that additional mail. We need to evaluate whether it will change the outcome of that case. And so we have to have people have the ability to, number one, know that there is a case that it applies to, and number two, put that additional mail into that electronic case file and route it to the right person. And so we have some categories of people, namely people who generally deal with additional mail, that are not prevented from seeing those. So I already mentioned that the vast majority of people are prevented. We do have the managers, which is Melanie, myself, and the assistant chief trial counsels. We also have people who are assigned to data entry. For example, they process complaints and additional mail. We have people who are assigned to file retention, and they also deal with additional mail issues and file retention requests. People will send them documents and other things to be added to the case management system. They need to have access to all of those cases. And other people who are assigned to process incoming communications. We have people who are serving in the role of intake paralegal or paralegal assigned to our intake unit, and other intake personnel who are assigned to respond to requests for complaint or discipline histories. They are allowed to see those cases automatically. And also any people serving in the capacity of administrative supervisor. So we have 3 Odyssey subject matter experts who oftentimes run down problems with our case management system. And we also have 2 senior administrative assistants who have the ability to see those cases as well. So it is anybody who is a line attorney or investigator who is looking at a case, evaluating or at a complaint, evaluating whether to send it forward to investigation or evaluating a case to determine whether to end up filing that in state bar court. Those are all routinely prohibited from seeing these archived cases.
Steve, I think we have, so this is you had a slide that listed all the people who do have access. That's what this is, right?
Yes.
Okay, great. So these are the people who do have access, and the people
Yes.
who don't have access are the investigators and attorney. The
Yes,
intake. Go ahead.
correct. Investigators and attorneys do not generally have access. They can get access to a specific case if necessary, based on the prior that I mentioned to you, essentially the 1101B character evidence equivalent of the evidence code. But generally, people do not have access, with the exception of these people for limited purposes, but none of those generally fall into the category of evaluating or investigating a new complaint.
Thank you. Okay. Oops, sorry. There we go. We can take any questions that you may have about this process.
I think Judge McGill has his hand up.
Yes, thank you, Shanae. Lisa and Steve, are there any statistics being collected about how often requests are being made and how often those requests are being accepted or denied?
That's a great question, and one that Lisa asked me this morning. I can tell you that we have, I believe, 3 requests have been made since November to unarchive a case for somebody to look at something as it relates to moving forward or prosecuting a current case. Not many is the answer.
Were all 3 of those granted?
I believe those 3 were granted, yes.
Okay.
Thank you. Any further questions? Okay. Ms. Chavez, are we going on to the next part of our presentation, how the State Bar implemented Professor Robertson's reform?
Jerry Larkin has his hand raised.
Oh, Mr. Larkin, I'm sorry, I didn't see your hand.
The late raise, I had a tough time finding the button, sorry. I just, I could commend the effort to archive complaints. And we have a different model in Illinois, and maybe the other states do as well. And I think any discipline authority is going to make a right choice for themselves. I think the weakness, though, is that lawyers who may wonder whether there is a file on them that is in perpetuity have no comfort that there isn't. The studies we've looked at are trying to have us create some system where confidence would be instilled in lawyers, that there is no improper correlation between historic records and discipline. And so I just wonder whether this is going to achieve that. As much as we've worked very hard in my state to engender confidence in what we do, as an educator like California is, there's a sense of distrust. So really, if that exists in California, then the answer to that is we have all these records. We're hiding them from all on staff except that list of people that we're allowing it to be viewed by. And even if it's necessary in a later proceeding on a newer case, it can come back to haunt you. I don't think we've ever felt as if we've been deprived of information we need by a more direct expungement, elimination of record. Of course, expungement doesn't mean that you can't go back to the underlying facts. When we close a file, we send a note to the lawyer saying, this is closed. It may be reopened, but know that in 3 years, absent some deferral circumstance, it will be gone forever. So keep your copy of the file in case the complainant comes back later, so it can be addressed. Rarely happens, but I guess forgetting the local differences, my question is this system where all that data is on a Tyler supported Odyssey database, is that going to change the confidence that the bar has in the process? I'm not sure it would in Illinois.
Thank you, Mr. Larkin.
So Chairwoman Buffington, I think
Yes.
that where staff is looking for direction here is Professor Robertson made 2 recommendations and the state bar kind of adopted a hybrid. He said to get rid of all complaints after 5 years and then archive complaints immediately if there is no discipline on them. And we have decided at the state bar to implement the hybrid of that, which is archiving after 5 years. This subcommittee is tasked at reevaluating this. And so this is where I'm looking for, does the subcommittee think what was implemented is enough? Does the subcommittee want to look at, truly expunging records after 5 years, maybe implementing what Professor Robertson recommended? And so this is, we've kind of heard, Steve, how it's implemented, and it's only, I think, 3 cases over the last 10 months or 9 months. But I'm hoping that maybe we can hear from other subcommittee members, their thoughts on this issue and whether or not we should revisit this.
Thank you, Mr. Ure. That's a good point. And these changes were implemented last year. Is that correct? The hybrid model was implemented last year, late last year, middle of last year, beginning of last year.
The board adopted it at, I believe, the July meeting was the resolution, and we implemented this in late October, early November was between the technology side that obviously Melanie issued the directive immediately that staff was not to consider it. But as far as the technological archiving piece with the security group through Tyler, it took us a couple of months to get that rolling, but that has been in effect since late October, early November.
Thank you, Mr. Moet. So I guess another question for the group is, I don't know, it was just the changes were implemented late last year. I mean, is it something that we want to reconsider providing further recommendation on, or is it kind of a wait and see approach to see how it is impacting our process as it stands now? I don't know. I see a few hands. Mr. Duran.
Thank you, Madam Chair. I think your point is well taken as to giving the organization some time to sort of analyze what effect, if any, the change in procedure has had. The other thing that I think is important to think about is, as the subcommittee may know, the board has approved the addition of several, I think 4 members of the public to the ad hoc commission as a whole, and I'm assuming some of those people will be very interested in the work of this subcommittee. And this is an area where I think the perspective of the consumer as to, are these issues something that they look for when they're retaining counsel, if they knew about these issues and in terms of the history of the discipline against counsel for these reasons, how would that affect their shopping choice, for lack of a better word? So I would suggest that maybe this is something we pick up after we have had those folks join us, and I'd be particularly interested in the consumer perspective on this.
Thank you, Mr. Duran. Makes sense. Melanie?
Thank you. I also like the idea of the wait and see approach. I know that this is the fairness subcommittee, and we want to make sure that we're achieving fairness. It might not mean that it feels fair to people, sort of a nebulous thing that we're trying to put our finger on, but we're trying to make sure that it is fair. I think some of the challenges that we come up against if we were going to pursue something different is just the reality that there are some instances where we're required to actually report, for example, complaint histories. The commission that evaluates judicial applicants, for example, we're required to report complaint histories to them. It is true that we get a number of people whose cases or complaints have been closed for a number of years who come back to us. It's a healthy number, surprisingly. And I appreciate, Mr. Larkin, your comments about how you handle it. I would be a little bit concerned, given the volume that we know exists, whether or not that would be really feasible for us. Also, the bar has a life of the bar requirement in terms of records retention. That is something that we would have to address. And then, overall, it's also the rub that our office is challenged with. And that is, there is some value in some instances to having the ability to look back at a complaint history of someone, even complaints that don't result in discipline. And sometimes it's more telling to look back and see if there's a pattern and help that inform how you're handling cases going forward than just handling the case in front of you. So there is a real balance to be had with those kinds of considerations.
Which I think is the issue, right? Like your points, Melanie, are really spot on, but we don't know where causation and correlation start and end. And we too look at patterns. We haven't felt like we've been limited by having cases destroyed, the record of cases. But part of the reason we went our way is we thought judicial evaluators, I didn't, I was a blue ribbon committee, I was a staff supporter of it, thought it was unfair that dismissed complaints would be considered by judicial evaluators because by definition, those were determined not to merit a professional regulatory approach. So well, every state's going to be different on this, is how I see it. And I think they're really great ideas in probably every state that has chosen its own path.
Thank you. Ms. Good, I see that your hand has been up for quite some time. Sorry.
That's okay. Thank you, Madam Chairperson. I wanted just to kind of add kind of my thoughts here. Personally, in light of the, really grotesque racial disparities that were uncovered, I think from my perspective, I think what would be most fair is to have some sort of exculpatory system rather than this halfway point. To try to ameliorate and redress some of those disparities. As you all know, the criminal justice system has a very robust exculpatory system that works well. Other states, including Illinois, as Mr. Larkin has pointed out, have exculpatory systems. I really would love for us to look at doing something a little bit beyond what is currently in play. That said, I also recognize that the current regime, which was put in place late last year, required an incredible amount of thought and analysis. And I appreciate all of the hard work that everybody did to kind of really think through the issue of trying to do some sort of midway point and to compromise on it. It took a tremendous amount of work, and obviously the data isn't in yet as to whether that has been effective. And I would hope that in a couple of years, we would look back and say, has this actually really kind of redressed the problem, or do we need to go one step further? So I guess I'm sort of where I'm coming out is I'm okay on the wait and see approach, just to give this some time to percolate through the system. It did seem to be done very thoughtfully and carefully and analytically, but I also just think that exculpation is kind of the way to go. to really redress the harm that's done to attorneys by having this kind of blemish, on their record. I guess also to Mr. Duran's point, it would be very interesting to see what the new members have to say on this, from the consumer side or otherwise. And I think, multiple viewpoints are always a welcome thing. If there was kind of a consensus to move in the direction of exploring some more bright line exculpatory scheme akin to the criminal justice system, I certainly would love to be involved in that, and I would share and welcome it. But if I'm a minority view on this, so be it, and we can just take the current system and see what it looks like in a couple of years. Thanks.
Thank you, Ms. Good. Ms. Joseph, you have your hand raised.
Thank you, Madam Chair. I guess I would like to follow up with what Ms. Good said, and I agree with what she's saying. And I think if the disparity wasn't so large, 46% of African-American males is very, very high. And no matter how unbiased we try to be when we're going back looking for patterns or looking at the prior complaints, that does trigger some implicit bias that someone has a prior complaint in and of itself, whether it was founded to be true or not. And so, I feel that that those individuals are already starting at a disadvantage and at getting a fair shake, for lack of a better term. And that I do think we should wait, as Mr. Duran suggested, and see how it shakes out. But at the same time, when Ms. Lawrence said that, that we go back, or the state bar goes back to look at some of those complaints, that just struck me a little bit. I hesitated or paused for a minute, only because of it's 46% of African-American males that we're going back to look at. And if we're using that, if we're here for fairness, and if we're here to address that as a disparate percentage, I think we have to think through how that does not weigh against those individuals to continue the pattern of disparate effect. And so I would agree with what Ms. Good has suggested in that regard.
Thank you, Ms. Joseph. Melanie, do you want to respond? I know Steve had stated that 3 requests have been made to access archive complaints since November of 2020, and that the 3 were granted. But there was a pretty long list of persons that had access to the archived complaints. So like, how does that work? Is it just like carte blanche? They have access and the case comes through? Like, how can we get a little bit more information on that? I know you probably already covered this. Just want a little bit of information.
Sure. Well, in terms of the list of people that have general access to even the archive complaints, these are not staff members who are evaluating new complaints. So, for example, the data entry folks, a paralegal, for example. So they're not the attorneys who are evaluating complaints. Those people, if they did want to see archived complaints, are the people that have to make the request. And I just wanted to note, and I recognize the concerns about looking back and even to cases newer than 5 years. I don't think, I don't want to leave the impression that that's a standard operating procedure. I don't want to do that. I think that it would be more common to do that where you have complaints, where we have a volume of complaints, for example, over the years. And it is not always either with the intent of disciplining someone, but it could be, for example, an indication that someone has some law practice management issues that if we wanted to be more proactive about, which we haven't gotten there, but is certainly on our minds, that we could reach out to those individuals and provide them some resources. But yes, then there is the other side of the coin, which I can appreciate as well.
Thank you, Melanie. Any further questions or comments on access to archive complaints? So I believe what I'm hearing from the group is that we should kind of wait and see how this is impacting our discipline system. We have public members joining us. I don't know exactly when, hopefully before our next meeting. And this issue will probably come back up at our next meeting to kind of get our public members' perspective or consumer perspective on maybe other areas we can explore as it relates to accessing archive complaints. Am I missing anything, Justin Chavez?
That's what I heard.
Okay, let's see who's up next. Oh, well, it is 11:43. I know we're scheduled to take a break here shortly. Should we jump?
Yeah, I think I can get through the website stuff. It's more informational. We may need to pick up the discussion on the other side, but I can at least present what's on the website before lunch and to keep us on time.
Thank you.
Okay, so Lisa, if you will start. I'm going to present to the subcommittee briefly what is on the website. And the State Bar has two websites that are somewhat independent of each other. One website is what people typically think at the bar is the attorney profile. So if you go onto the State Bar's website, they say to look up an attorney, you type it in there, and that's when the attorney profile page comes up. And if someone has discipline, depending on when that discipline took place, there could be documents on the attorney profile page. It also has a State Bar Court website, which is separate of itself. And it contains actual documents that are filing in the Odyssey system. And this was implemented in 2019. And you will see, I will show you shortly, that the two sites kind of work together to get the complete picture out there. And then I'm going to talk briefly about what administrative actions, remind the subcommittee, are currently expunged. The reason I'm going in depth on the website, if we go to, is in response to public comment that we received at the last subcommittee meeting. There was a gentleman from the public who had a public approval over 10 years ago and was trying to find employment and found it very difficult to find employment because that public approval was still on the website. And if you go to the next slide, Lisa, we provided the subcommittee this information last time. And so we did a comparison on attorneys versus doctors. And that same public member, or same attorney member, if he was a physician, that public approval would have been off the website. So someone going up to look up his physician page would not have found that public approval. But for attorneys, it stays on there forever. And so what I want the subcommittee to think about as we talk about this discussion is if we don't expunge the discipline, that's a later discussion, but maybe there are limitations because some other states we found have limitations to the amount of time where something stays on the website, trying to balance public protection, but also not disproportionately impacting the attorney. So if you go to the next slide. So this is the State Bar website. I picked Mr. Avenatti because he's very public and because he has discipline that is old and new. And so it was a good example for me to use. He has many consumer alerts. We brought these up last time. Each of these, he has 3 different ones because he has lots of discipline and they talk about the impact of his license. And it also talks about the impact that there might be fees that were misappropriated. So if you are dealing with this attorney and fees, it gives a broad alerts to consumers to let them know that this person is currently not eligible to practice and there are specific areas where malfeasance may have occurred. If you go to the next slide. This is where it talks about his licensing status, disciplinary and administrative history. So from the beginning of your licensure, all the way, see it says admitted to the bar, all the way to present day. This will have a complete listing of every disciplinary action that is public. So if he has a public reproval, a suspension, a disbarment, any of those things, it will show up here on the website. Down below the state bar court cases, if there are cases that took place prior to the implementation of the Odyssey system, they have been scanned and added to this website. And so this is the attorney profile page, but the state bar court cases will be on this website and accessible from here. If it is newer, then the next page, please, Lisa. You will be asked to go to the state bar court. Oh, it went a little quick, but you will be asked to go to the state bar court website and enter in the case number. And that's where the documentation and case filings reside in current cases. So there's kind of a difference. If it's older than when we implemented the system, it shows up on the attorney profile page. If it's newer, you have to go and search on the state bar court, and there's a link provided, and then you go to the state bar court website and you can search all the documentation. If you go to the next page, Lisa. And so this is where you can search for a case, you enter in the number. And so I copied one of Mr. Avenatti's prior cases, and the next slide, Lisa. This is the case information from the state bar court website, and we call it the red website. And so it has all the information. It has party information, events and hearings. And then if you go to the next slide, Lisa, it shows all the documents. So it has every single document from this case on the state bar court website. And so the reason that I'm bringing up this distinction is there may be, the committee could decide that they want to set a limit for what is on the attorney profile page. And they will also need to consider whether or not that the state bar court should only have things available on its website. Now, as someone previously mentioned, the case file is for the length of the bar. So there is no expungement of any records. They're permanent for the life of the bar. But on the attorney profile page for low-level discipline, this subcommittee could take in, and I'm asking for this discussion now, is there interest in what potentially could be a length of time where something would be pulled down from the website? It would still be available in the doctor's case. You could still call the medical board and get access to that. And there could be potentials where it's removed from the public profile, but also available on the state bar court website. So if you searched over there, you would get it. But if you looked at the attorney profile page, you would not. Now, I say this knowing that we are getting 4 members of the public, and public protection is a primary focus of the state bar. And so there is the balance going on as public protection and the public's right to know, and then the disproportionate of old discipline impacting these attorneys, and obviously the Farkas and Robertson reports. If you go to the next slide. So this is what is currently expunged from the attorney profile page. You can have a one-time expungement. These are both administrative suspensions. So if you did not pay your licensing fees on time and you got suspended, or if you did not complete your MCLE requirement in a timely manner, you were administratively suspended. And you can petition to get both of those things taken down from the website currently. There is no expungement for the criminal convictions, but that's an area where we will discuss later. If you go to the next slide. So this tells the only avenue to remove a record of public discipline is by requesting expungement from the California Supreme Court. That's the Business and Professions Code. And so, can you go to the next slide? And this is for a later discussion on that expungement does not mean the record is destroyed for all purposes, and also bringing it down from the website does not mean that it is destroyed for all purposes. These talk about exceptions to expungement, and I won't read them, but you can read them on the screen, the rules of court 9.8 and 9.31. And so, Lisa, if you can pull down the slide deck now. So that's presenting what is on the State Bar's website. There are two websites, the attorney profile page and the State Bar Court page. And so I'm happy to answer questions now, but the reason we bring up this discussion is in response to the public comment, Mr. Freeman's public comment last time. And if this subcommittee is interested in looking at different ways to approach this.
Thank you, Mr. Ewart. Mr. Lear and then Judge McGill.
Thank you. Thank you, Justin, for that. So for those of you that don't know, I'm also on the other subcommittee. And those of you that overlap like I do, I apologize for repeating myself, but here goes. And that this has been a bit of a rant of mine for a little bit. And that is this idea of expungement. I favor it. I think that it is unfair to respondents who have hypothetically had 2 DUIs, let's call it a public approval, where both of the DUIs have been expunged. So with respect to the criminal justice system, those DUIs are erased. And yet that same attorney with a public approval based on the two DUIs will have that public approval on his or her record for the rest of his life. And so to me, there's just a fundamental unfairness there, and we need to catch up, and we need to have an expungement avenue for them. Justin, I did not know about 6092.5. That's interesting. I'd still think that that's a Hail Mary to try to get the Supreme Court's attention to expunge the hypothetical that I just gave you. So in that regard, I find that fundamentally unfair. There are virtually many other examples where there would be criminal convictions resulting in state bar discipline. I'm not arguing against that. I'm arguing that to the extent that there's been an expungement of the criminal convictions, that there should be a corollary expungement process in the state bar context. I gave this example the other day, and I will give it again, which is the Department of Real Estate. I handle many DRE defense matters as well. And the DRE there's been legislation passed that allows for a category of minor discipline to be expunged after 10 years. And that was, interestingly enough, championed by Rob Bonta while he was a state, either assemblyman or senator from Oakland, and who is now our Attorney General. So that seems to be pretty effective with the DRE. Anecdotally, once that became effective, my phone was ringing off the hook for people that were in that category who wanted their DRE discipline expunged. So I think that's something that should be explored. I think it's better explored here, frankly, on the Fairness Committee than on the Effectiveness Committee, which is where I brought it up. And I think that some of the responses to me when I brought it up on effectiveness was, well, that should be a fairness issue. Further, different anecdote, and sorry to spend so much time, but these are issues that on the defense side, we deal with on a daily basis. When a notice of disciplinary charges is filed, that then goes up on the membership record. And my rant there is that you are guilty until proven innocent. And that is to say, scarlet letter, you are not going to get hired if you have charges against you. That's been the perception that I have gleaned from hearing about this for many years from my clients. And in particular, there can be a monetary loss associated with that. So about 6 or 7 years ago, there were 17 charges against my client, all 17 charges dismissed at trial. In that case, my client quantified that he had lost $150,000 during the pendency of that year plus as a result of his business declining. And there were serious charges, including moral turpitude and scheme to defraud. And in that case, he had a situation of very constant income for a long period of time. So he was able to pretty accurately say that $150,000 has to have been a result of the red box on my membership record. And he's an estate planning guy, so you can imagine that it was particularly interesting to his clients. I'm digressing a little bit, but that's also a fairness issue insofar as I hate the red box. And the red box without any charges having been proven has a very detrimental impact to my clients. And I believe that's a fairness issue as well. But let's stay right on the expungement. So the expungement, I gave you an example. I think it's high time that the State Bar, and particularly this subcommittee, address the issue of expungement, especially in the context of very lower level stuff. I don't have a proposal at this point as to what to do with cases that involve actual suspension and whatnot, but certainly anything that's in the neighborhood of a private or a public approval, I think is something that's recognized or should be recognized by the whole system as lesser discipline, where an expungement option should be on the table. Thank you.
Thank you, Mr. Lear. Judge McGill?
Yeah, first I have a question, then I have a comment. So regarding the consumer alert box when charges are filed, like what Mr. Lear referred to, I have always worked under the assumption that that does not apply in every time an NDC is filed. I think we can all benefit from some information about when the consumer alert box is actually put up on the website and when it's not. And then my comment is that I think the gentleman that came last time, it wasn't just so much about the public, that the fact that the thing was up on the public website. It was, of course, in employment applications where he's being asked about bar discipline. And I think this gets back to Mr. Lear's comment about criminal expungements, because my understanding under criminal expungements, you don't have to, once you achieve an expungement, you don't have to disclose the criminal record, the criminal past on employment applications. I might be wrong about that, but I think I'm pretty accurate on it. So I think that's what his concern was going to in making employment applications and wanting to be truthful. But, you know, I think an expungement is what he was looking for, not just so much from what was on the public website.
Thank you, Judge McGill. Oh, Judge McGill, you had a specific question. I'm trying to think who would be best to answer that as it relates to the consumer alert on the website.
Yeah, I would assume Melanie or Steve.
I can try to answer the question. It was under what circumstances it gets posted?
Yes.
So it depends on the nature of the alert. There are, I want to say, 6 different categories. There may be more. And so it would go up. For example, if we file a petition under 6007C saying that somebody's a substantial threat, it would go up upon filing of that petition. And then there would be notice there. So if, for example, the one that says that something is pending, just something pending, is actually not a red box consumer alert, there's a notification that would eventually go up, but that has not started yet. So it's not a situation where we file a notice of disciplinary charges and that notification next to the license status on the State Bar profile page is posted yet. So it's only the consumer alerts, which are fairly narrow.
Well, for example, on the one that Justin showed on Mr. Avenatti's public page, I think it was the second one, says that he's been charged with major misappropriation. It doesn't just say misappropriation, it says major misappropriation. So is there, for example, some sort of triggering mechanism when misappropriation is charged? Is it above 5,000, above 10, less, you know, that kind of, that's what I'm looking for personally.
Yes, back in 2011, the Board of Trustees approved a resolution that the that an alert be posted on a major misappropriation, which I believe at the time and remains still defined as $25,000 in client funds. So if somebody misappropriates $25,000 or more in client funds, that alert would be posted.
Thank you, Steve. Any further questions? Okay, Ms. Good, you have your hand up.
I just wanted to say, as with respect to the prior issue on archival, I wholeheartedly support having more of an exculpatory system here than what is presently in place. As I said before, the criminal justice system has a very robust exculpatory scheme. They've, balanced kind of the convictions versus what can be exculpated, and under what circumstances. Other states apparently have an exculpatory system for attorney discipline. I wholeheartedly endorse that to redress kind of the severe racial disparities that we see in the discipline system, and just as a matter of just fundamental fairness, so that people can, make a mistake and it's not going to wreck their lives forever. They have a chance to improve, get better, move on, and continue to practice law. Vis-a-vis the two issues that Mr. Lear raised in terms of the imposition of discipline, I support exculpation. On the pending charges point, I can see that there are very good reasons to have pending charges on one's state bar profile. And so I don't know that I support that aspect of it, but just wanted to kind of reaffirm my support for an exculpatory scheme generally, if we decide to go in that direction. Again, subject to my prior comments that we have this kind of interim scheme in place. We haven't evaluated it. We have new members coming, but just wanted to kind of add that. Thank you.
Thank you, Ms. Good. It is now 12:04. Maybe a good time to take a break. We've been going for a few hours here. Then we can reconvene. I think our lunch is usually at it's around 30 minutes. Ms. Ure, where are we going to pick up after lunch? Just to kind of give the committee a heads up. Are we going to go straight into expungement of post-conviction discipline, or?
Yeah, I think all the conversation comes together, and Ray had to jump off this call. So I was really hoping he will be back after lunch. So I think it's a good time to take a break, and then we can kind of tie up this discussion and then talk about the stuff with Ray after lunch.
Okay, and I'm assuming the expungement discussion will correlate with the removal of low-level discipline on the website. Is that correct?
Yes, potentially.
Okay. Thank you. So I guess we'll see everyone back around 12:35.
Okay.
Or you can hang, or I guess we can hang on, right? If we just mute ourselves, can we just stay on, or do we have to jump off? Okay.
Sure.
Thank you, everyone. Back at 12:35.
All right, we are recording once again.
Thank you. Okay, so where we left off was removing low-level discipline from the state bar's website.
Right. And that's where the discussion, because we've talked about two kind of distinct things. One, removing from the website, and then also just expungement in general. And that's where I'm glad Ray is on now, because he can kind of talk about it from the criminal point of view. I wanted to make two clarifications. One, between the attorney profile page and the state bar court page, even if a even if a case is dismissed, it stays on the state bar court page, the red page, because it is part of the permanent record. And so the permanent record is for the life of the bar. And so I was made aware and wanted to bring that information to this subcommittee, that it does stay forever on the state bar court red page. And so I'm hoping to get direction if this is something, because I understand that it is confusing that we have two websites, and maybe a better breakdown of what is specifically on them and for how long might aid the subcommittee's decision on moving forward with that, if that's an area where they want to pursue. So this is more what I would like out of this discussion is if the website is, the length of terms of low-level discipline on the website is something that they want to pursue. And then also expungements, post-conviction expungements, if that's something that they want to pursue.
Thank you, Ms.
Okay.
Ewer. I think, go ahead.
Do you want me to go, Madam Chair?
Yes,
Okay.
Mr. Bonaventura, yes.
Thank you,
Thank
Madam Chair. So just a reminder on the expungement process and procedures, at least in the criminal context, so we have sort of a backdrop. So again, expungements are for what you do after conviction. It's basically post-conviction relief. Now that's distinguishable from diversion, which is what you do before any conviction occurs, at least in the criminal context. And I think we are here today to see if we can achieve a consensus moving forward with a recommendation to implement some sort of expungement process. So the details, I mean, I'm hoping that there is, and I'm hoping this committee makes the ultimate recommendation to act on expungement. And I think for our purposes, the details of the expungement procedure and process is what we need to figure out. So some of the issues I think we should consider are, number one, whether or not we implement a system where it allows the respondents to have mandatory expungements versus discretionary expungements. And so obviously mandatory is just that. They are automatically entitled if they fit certain criteria, and we would come up with that criteria. Discretionary is obviously, it's at the discretion of whichever governing body makes that decision. And that could be granted based on, at least in the criminal context, it's in the interest of justice. So, so we need to basically decide and discuss what kind of acts should be automatically expunged or be granted as a matter of right after a certain probationary period expires. Remember in my last discussion when I talked about discretionary expungements, that's where the respondent has to put forward reasons why their expungement should be granted. And the example I gave previously was, for example, in a DUI conviction, an expungement can be granted by submitting a declaration of how they've actually changed in their life, what they've learned from the DUI conviction, and how they've been rehabilitated somewhat. Example, an example declaration that has worked, at least in that context, is I declare that I have stopped drinking, or that I never drink and drive, even if I have a sip, or that I always take Uber whenever I go to an occasion, or I have taken the keys away from people who I've noticed drinking, or how the conviction has even prevented better job opportunities for me, and how it has affected the livelihood and the business that I've engaged in. So that's the discretionary, and that's by way of a declaration. And then I think we have to decide the process. Who decides whether or not an expungement is granted? Is it the staff? Is it the commission? Is it a committee? Or is it the courts? And that's, I think, integral about the process and how it's going to get done. And then the final thing is probably the most important, which is what effect does that expungement have? What does it mean to get an expungement granted? Does it mean that the record is destroyed? Does it mean that the record is sealed but not destroyed? Does it mean deletion from the public website? Or does it mean that you simply are allowed to deny any improper action attributed on your part in any questionnaire? Because in the criminal context, when an expungement is granted, what that opportunity allows you to do is to deny that you have ever been convicted of something. And then technically what happens is your plea of guilty or no contest, as it was originally made, your conviction, is set aside and substituted a plea of not guilty. And so it's still on your record, but it shows that your case was expunged, and the finding is that it was a not guilty finding. So those are the things I think we should maybe try to focus on: the process, the cases, and the effect. So thank you very much for the opportunity, Madam Chair.
Thank you, Mr. Buenaventura. You posed a lot of questions for discussion. I think the question at the outset is, is this subcommittee interested in recommending expungement, and on what terms and conditions? I think we're all, I'll speak for myself. I think we're all interested in having some type of expungement procedure in place outside of, I think earlier there was some information that expungement would have to be requested from the California Supreme Court. So something a little bit more further than that. Does anyone have any questions, thoughts, or concerns? A good point that came up is, if we recommend expungement, like what matters would be eligible for expungement? I think that's a pretty big one, and something that, I don't know, we need more information from the state bar. Is that something that we can just kind of start brainstorming about right now, and then have some follow-up at a separate meeting?
Well, when I think of the expungements in terms of what we've been talking about, and some discipline is not even founded. So at a minimum, the matters that have not resulted in a conviction or a public reproval or whatever, those should be, I think, our top priority for getting them expunged, because we're using these matters against people for progressive discipline, or looking at it in terms of a violation. So at a minimum, I think we should be looking at those things. And then the second area is maybe if it's a minor violation that could be corrected by a class or a course, those should be the next level. And then looking into the banking errors, I would think that those that just seem to be an oversight and small amounts or improper balancing of your books, but not an intentional act, those also should be subject for the expungement. And I think it should be within maybe it is the 5-year term period that you kick all this stuff off.
Thank you, Ms. Anderson. I appreciate your comment. Thank you, getting the conversation going. Judge McGill?
So one of the things you might want to keep in mind is if you want to look at expungements just for things that have had minor levels of discipline, for example, where there's been private reproval, public reproval, or even perhaps a no suspension but probation. And then you also have to look about, like what Ms. Anderson was talking about, maybe another way looking at expungement just based on the types of acts, because how this can get a little confusing is with our standards on progressive discipline. So you can actually have a fairly minor act that can become a little bit more magnified in its impact on someone's practice at that point, because they've had an earlier prior discipline. So for example, something that might be just a bookkeeping error that could have gotten a public approval the first time around. If someone already has a public approval and the act itself is still very minor, it might wind up actually being something in the range of actual suspension because of the progressive discipline and the existence of the prior discipline. So it gets a little confusing. And I think Ms. Anderson's point is correct. I mean, a lot of times the acts themselves are minor, and maybe there should be an expungement process that looks at the particular act and not necessarily at the level of discipline. And also could be also the level of discipline if in and of itself is minor.
Thank you, Judge McGill. Okay, I see a few hands up, Mr. Salig and then Mr. Larkin.
Yeah, so so I agree that expungement is something we should look at. I think what we need is some specific language, maybe it's modeled on the criminal equivalent or the DRE, but just some ideas to throw out. I mean, to me, it's kind of a no-brainer that if a criminal conviction is expunged in the criminal system, that it should be expunged in the discipline system also. And I also agree that minor offenses after a certain amount of time should be eligible for expungement, but I think it should be discretionary. And what we need to do is have some factors. And then it would presumably go to the state bar court and they can make a recommendation to the Supreme Court, because I think the statute that Justin cited to us reminds me that really, because the Supreme Court in almost all cases is the entity that has exclusive jurisdiction over discipline, that the Supreme Court is going to have to be the entity that actually does the expungement. So, but so anyway, those are my thoughts. I think we need to find a way to start developing factors, and there are other places where factors have been developed and we can probably adapt them to this context.
Thank you. Makes sense. So we're not reinventing the wheel here. So you said possibly look to Department of Real Estate and the criminal context, right?
Correct.
Okay. Thank you. Mr. Larkin?
Thanks, Shanae. I'm intrigued by this conversation. I don't think that many states have really pursued expungement in the way that applies in the criminal context, as Ray indicated. Now, maybe I think Steve or Melanie obtained some data from other states. I'm just not aware of it. But I think society is changing to the better on second chances and not tying people to the past. But it's something new to me, so I'm just interested in listening and learning. I think historically, lawyer regulators drew a sharp distinction between criminal and regulatory. And I just mentioned that as an historic view. For example, one can be pardoned of a criminal offense, but it would not affect in lockstep, either discipline or reinstatement. So there is some difference there. And I'm just struggling with the concept, but I think we'd be breaking some new ground here, which is, I never opposed that idea. I'm interested to hear what others have to say.
Thank you, Mr. Larkin. Mr. Salig, you see your hand up. I don't know if that's from before or.
No, I forgot a detail I meant to mention, which is going back to Judge McGill's comments. I think I would be inclined to think that if we have this expungement process, that it means that the discipline that's expunged is not something the public will see on the website, or if they call the state bar for information about a lawyer. However, I don't think it should be erased internally, such that for purposes of progressive discipline, OCTC would remain aware of the prior discipline and would be allowed to put it into evidence in state bar court for purposes of a subsequent discipline case. So I wanted to throw that out. And also, I'm not sure we've kind of mentioned the 5-year period. I'm not sure 5 years is necessarily the right period. Maybe it is for some really minor things. But I'm thinking a longer period, more like 10 years, because I was just looking at the record of an attorney who I was hiring actually. And this person had discipline that was like from literally 25 years ago. And I decided it was just so old that I just didn't even care to look it up. So, I think this is a fair process to think about when something has just become so stale that it's just really not of interest to the public.
Thank you, Mr. Salik. I'm not sure where the 5 years had come up. Mr. Buenaventura, is that something that you have proposed or?
No, it wasn't me.
Okay.
Yeah.
Okay. Is Mr. Lear?
Hi. So while we were talking, I just looked up the DRE expungement process that I mentioned earlier. And what I note here, and I didn't necessarily know this before, but it's informative to our decision or to our discussion, is that it's not fully an expungement. It's seeking removal of licensed discipline information from the department internet website for licensed discipline and with an effective date more than 10 years prior. So the point of that, and this is what I was speaking to a little bit before, which is my clients care about their membership record on the website, because typically what happens is you Google Ed Lear and the first thing that comes up, one of the first 3 things that comes up is your membership record for the state bar. You might get Facebook up there, you might get LinkedIn, but your membership record comes up. So if you have discipline, it's a pretty easy move for that potential client who is Googling one's name to go right to the membership record that he or she might not have known about, and then to see that there's discipline. So my clients care dearly about that. And so this process is about the membership record and what are the optic to the public, and less so about the issue of call it prior discipline for state bar purposes. I mean, I think that's a worthy discussion, but at least with the DRE crawling before they walk, the first step here was just removing it from the website so that these people can go on with their lives and continue to get business and go from there. That's an easy step for us, I think, in terms of I mean, I'm calling it expungement. I agree, but I'm not sure that the DRE is even calling it expungement. And they also, in this application, as I'm looking at it, they demand that there be a showing of rehabilitation. So even though you've had the criminal convictions expunged, there's still an additional portion of the application that talks about substantial relationship and rehabilitation criteria. So they've kind of thought through the process that we are going through now. So I think it's a decent model to look at in that regard. And again, first step, get it off the website so that these people can have a continuing chance to thrive in the practices that they're in. And Justin, I'll send you a copy of this application, and then you can choose to make it available to the subcommittee or not.
Okay, thank you.
Thank you. Just to follow up on your point, Mr. Lear, I think as we need to discuss as a subcommittee, when we talk about expungement, like what does that mean to us? Does it mean removing, the discipline from the state bar website? Does it mean that it goes away forever? Does it mean that certain matters can still be accessed by the Office of Chief Trial Counsel? Like, I just think we need to have a little bit more discussion on when we say expungement, exactly what are we envisioning as a subcommittee to put forth as a recommendation. Mr. Saliga, I see your hand is raised.
Yes, I'm just very chatty today. I don't see anyone else with their hand up, so
That's
I
right.
yield to someone else. But Ed's comments, I think, are important. And So I think what I was sort of proposing in my prior comments is really simply that certain charges would be dropped from the website at a certain point, but which is different than expungement, because that does sort of wipe out the finding of culpability. So the Supreme Court would have to do the latter to completely wipe out the discipline finding. Not sure what the word is. There's not, conviction's not the right word. Whereas if we're just talking about what is displayed on the website, that's something the board is in charge of and would be easier to implement. So, and the two are not mutually exclusive. So I suppose we know from statute now that there is an avenue to petition the Supreme Court for expungement. And so maybe we might want to have not only a procedure for true expungement, if we want to pursue that, and or a procedure to have information removed from the website, or simply a default rule for certain types of discipline that after a certain period of time, it just drops from the website. So I think this is a more complex task than at least I originally anticipated going into it. There's a lot to think about.
You're right. Thank you, Mr. Saliq. Ms. Anderson, you have your hand raised.
Yes, I guess I'm just really disturbed by the fact that even if it's a minor discipline or a complaint, that it can stay on your record and then be used for progressive discipline. That's troubling to me, because what if I really didn't do it the first time? And then there's this record that I had a complaint against me for doing something, I don't know. And, maybe I just had an angry client. And if we don't implement a method of having these things removed, then it could really cost you, because even if you were guilty and did do the second violation, you have a record that now is going to compound what you did and make it worse. And if we are truly trying to give people second chances, there must be a better way. And maybe we do a bifurcated system that, certain type of violations, if you want them forever, expunged or whatever after a certain period of time, if they're a more serious one, then yes, you have to go to the Supreme Court for that. But for minor violations or a certain type, we categorize them that you can, get an expungement. I don't know, maybe use a preponderance of the evidence standard for the more minor offenses and allow that to take place. But I just find it very disturbing that you can have progressive discipline based upon an unfounded complaint.
So it's, when you think of expungement, it goes beyond just removing something from the state bar website. I think you're on mute. Yeah,
I think so, because even in the criminal context, when you go for an expungement, you have to do certain things, complete successfully your terms of probation. And that's the problem with some of the statutes that we have out there right now in the criminal land. They said, I think it's under AB 1950, one of those sections for, in a criminal context, I'm using this as an example, where, certain crimes have been categorized as only being a certain period of time now for a probationary period. And if the defense attorney doesn't advise their client properly, getting that dismissal, the shorter thing, is not a good thing, because then it will prevent them from getting their record expunged in the future because they haven't completed their terms of probation. So I don't think we should be in that situation, especially with bar complaints, that if you have to show, that you've redeemed yourself or whatever, or there's a complaint that hasn't been fully founded on you, there has to be a way to clear your record without leaving a mark on it, at least for these minor violations.
Thank you, Ms. Anderson. See a few hands. I think Ms. Good and then Steve.
Yeah, hi. I think that, Ms. Anderson raises some really good points. And I think, as Mr. Seleg noted, this is a very complex, complex area. And, if we look to the criminal justice system as kind of a template, there are certain offenses that are automatically expunged after X number of years, and then other ones that are discretionary. And I agree with Mr. Seleg that I think the state bar court would make those recommendations or determinations. I just was wondering, Madam Chairperson, on kind of the process for moving this ball forward, because it seems as if we should have something more concrete in front of us to kind of consider. And whether or not you wanted to form a subcommittee from this group to do that, or to evaluate, for example, what Mr. Larkin has talked to us about is the state of affairs in Illinois or other states. But I just was wondering what was the next step. And it would seem to me that the staff should be very involved in that, in terms of determining which offenses they view as something that should be automatically expunged versus ones that should be discretionary, and what the right period of time might be. So I just wanted to kind of throw that question out there to you, Madam Chairperson. Thank you.
Thank you, Ms. Good. You make a very good point. I hate to keep saying this, but it's like more research, we need more information to make informed decisions. And I know we have one more meeting scheduled for August the 24th. I just, as I stated at the last meeting, I foresee us having another meeting just to kind of iron out some of these issues. So that's a good point, Ms. Good, that you made, is, maybe we should get input from the staff at the state bar regarding, what offenses would be eligible for mandatory or discretionary expungement if this is something that we choose to pursue. Right now, what I'm hearing, or what I've heard just from a few past comments, is that we are going to get more information from the Department of Real Estate, some factors that it considers. I don't even know if this is actually an expungement, but some factors that are considered when trying to either remove discipline from its website or thereof. Also, we were supposed to get some language or some more information on expungements in the criminal context, something that we can actually see on paper. We don't want to reinvent the wheel, but we most definitely want to see in other realms how the process is laid out. So it sounds like more research, and the staff have been primarily responsible for bringing information back to this group. But if this subcommittee thinks that it'd be beneficial to have a few members from the subcommittee to explore the issue of expungement further, because it's kind of all been falling on Ray at this point. I'm all for it, because right now it's just kind of like, okay, we're having a very high level discussion on what we would be eligible for expungements. It's kind of like, I just think we need more information. A few hands raised. I don't know, we'll give some people some time to think about a smaller group of folks exploring the expungement process further. Steve, I see your hand raised.
Great, thank you. I just wanted to bring out one important difference. Sort of, we've been using expungement and things, somewhat interchangeably, as Ray has done a great job explaining today and in prior days, that there are a couple of different avenues, at least in the criminal arena. And there's the declaration of factual innocence type of relief. There's the 1203.4 type of relief. And So to Ms. Anderson's point about a charge that has not been proven, that does not, as Judge McGill said, that doesn't serve as prior discipline to be used for progressive discipline, for purposes of progressive discipline, where there's just an allegation that was never brought to state bar court, that somebody was not, that was not found true by state bar court, and discipline being imposed. That, I think, at least the intent was to ameliorate that through the archiving of those closed complaints. Now, whether that does an adequate job of it is an open question, and certainly something this committee could and should address. But I think that piece is reserved there. The 1203.4 relief is somewhat different. And in the criminal arena, that, for example, is not required to be said, okay, I had this conviction. It was, I got relief under 1203.4. I no longer have to tell somebody on a job application that I suffered that prior conviction, except for certain jobs that, like government jobs. I think Ray went through that before, but certain classes of jobs, you do have to reveal that information, and it is still priorable. If you, for example, have 1 or 2 DUIs and you get those, dismissed, you get relief under 1203.4, you go out and commit another DUI, that would still be your 3rd DUI. And so in some ways, what Mr. Lear has talked about through the DRE is somewhat parallel to that criminal relief schema that Ray has talked about.
Thank you, Steve. Mr. Lear?
Thanks. Real quickly. So in our other group, we just Friday we had a meeting, and we had some issues that we broke out into working groups, and that's, Shanae, you were just about, I think, to do that, and I think that could be a really good mechanism for getting a little deeper into the weeds on this issue. I am not volunteering for that. I've got too much going on, but a working group might make a lot of sense here on the expungement issue. And certainly, I'm calling it the expungement issue, but I think we all know what we're talking about. If need be, I can put anyone in touch with DRE prosecutors that I know and or DRE people concerning the DRE model. And potentially, it'd be interesting to get some metrics there. How many people have applied? Have they seen any import from the application process? And it's probably 3 or 4, maybe 5 years into it with the DRE applications for not being listed on the website. But I think this is a very great, robust colloquy, and this is an important issue. Thanks.
Thank you. And Mr. Winfield?
Hey, good afternoon.
Good afternoon.
Good. I had a couple things I wanted to bring up. One, to what Stephen said about the expunged convictions being priorable. They are priorable, but like in the DUI case, you have to have a certain amount of DUIs within 10 years. So if you were to get your 3rd DUI 11 years, then that 1st DUI is not priorable. So there are mechanisms in place where you can make the conviction not priorable, and in the meantime have the expungement statute. So the equivalent here would be, in my opinion, would be to get it off the website or it's not reported, would be the interim one, which would be the expungement statute, in equivalent to the criminal statute. And then there's another process on top of that, say in 10 years, you could have it removed and it can't be used as a prior. Now that's something that you're kind of getting the best of both worlds. Now, I also wanted to bring up how to kind of address the, Black males being disproportionately disciplined. If you have the expungement process and these violations are still actionable, we are not addressing that situation. So I think there has to be a mechanism in place where these prior offenses can be removed completely from the record and therefore not be priorable. If we're stuck with the progressive discipline, we have to find a way to not make that priorable. And, you know, it could be an additional, you know, period that goes by there. And it could be a period per type of violation. This violation after 5 years is clearable. This violation after 10 years. It could be a violation that's never clearable, you know, never non-priorable. But I think that being in the situation that we're in right now, I think we have to find a way to clear people's record, especially when you're talking about the disproportionality. We can't go back. We got to find a way to go back and rectify that, in my opinion.
Thank you, Mr. Winfield. So what I'm hearing is that we need a smaller subcommittee to explore expungement policies and procedures that we propose to recommend. And
Shanae, I think we've got clear direction. I think the subcommittee has had a fruitful discussion with this. I think this is where I don't know if we could take a couple of volunteers to work with staff and flesh out these recommendations that we want to bring back to the subcommittee. I know Ray has a lot of expertise, so I'm not going to try and volunteer anyone, but if we could get maybe 3 volunteers total, so Ray and maybe 2 other people to work with staff, and we could reach out and flesh out these recommendations and bring them back at a future subcommittee meeting.
We got more than a few volunteers, it looks like. Looks like we got the whole subcommittee, well, almost. Okay. You see raised hands. If you would like to participate on the smaller working group of this subcommittee to explore expungement further, please raise your hand. Not physically, but on the Zoom feature.
Ms. Joseph, Ms. Good, Mr. Moad, Mr. Winfield, Ms. Anderson. Okay. I just have to make sure we stay below half of the ad hoc commission. Okay, I have taken it. So that was Ms. Anderson, Mr. Winfield, Ms. Joseph, Ms. Good, and Mr. Moad.
Okay. All right.
So just a point of procedure, Jason, I think you should check with OGC because that's quite a number of people. So we may need to thin it out a little bit for Bagley Keene compliance.
Yes, Trustee Salig, we checked with OGC after our meeting on Friday. And as we're not in any violation of Bagley Keene if we keep it under half of the full ad hoc commission, if it's an informal working group.
Yeah, understood. But my only concern I have is that then you're at risk. We're at risk of inadvertent violation, right? If there's then some communication to, if we have almost a quorum, right? Then through the daisy chain effect or through someone just having a conversation at an informal dinner or something, then you can develop a problem. So I'm not sure we want to get so close to a quorum of the committee, but I defer to OGC. I just suggest just double check with them about that.
Okay, and specifically what I've been hearing from subcommittee members, what we want to see is some information from the Department of Real Estate, is that correct, on their policies and procedures to remove discipline from its website, as well as factors considered for expungement in the criminal context. Is there anything else that the whole subcommittee would like the smaller working group to research, follow up on? It's good. I see your hand is raised.
I would just throw into that the other states that provide for expungement as part of their attorney discipline process.
Thank you. Okay. Mr. Ewart, where are we on our agenda? It's already 1:17.
Yeah, we'll catch up. I think we're at the point where I think Lisa's going to briefly, she can do it briefly, bring back Professor Robertson's policy options, and then Judge McGill can give a brief overview of the self-help materials he's been instrumental in developing.
Thank you. Ms. Chavez?
Mute. Okay. Hi, good afternoon, everyone. So we're kind of bringing back attorney representation because we want to share with you information that the State Bar Court has information about some action they've recently taken or planning to take with regard to develop self-help materials for attorneys. Before I do that, I just want to do one more review of the status of Professor Robertson's potential reforms, because again, as a committee, you know, the purpose which you all are tasked with is looking at the reforms that the State Bar is currently undertaking, asking if it's enough, want to modify it or recommend something different. So let's get started. As a reminder, he actually recommended five reforms. And the first we did implement, which is to start tracking and reporting on the proportion of discipline cases that have attorney representation. I shared that data with you at our last meeting. We also we're pilot testing a potential reform 3.2, which is to inform attorneys facing discipline about the increased statistical likelihood of discipline without counsel. So we described the letter that we are pilot testing with half of all attorneys who are facing investigation. Potential reforms, let me just skip ahead to 3.5. He also recommended creating a discipline equity office to minimize disparities and support unrepresented attorneys. We couldn't prioritize that at this time due to lack of funds and bandwidth, et cetera, to kind of develop what would essentially be like a whole new office at the State Bar. But this is something we're not taking off the table. We just didn't prioritize it to explore this year. So with regard to 3.3 and 3.4, this has to do with, they kind of work together. It has to do with developing a roster of attorneys who agree to provide low cost or pro bono consultations, working with AGDC on that, developing that roster, and also kind of facilitating developing a sliding scale for fee representation by the private defense bar. And so this is work that Professor Robertson is taking the lead on. He's working on that this year. When he presented to you last month, he shared the status of this work, and he shared some kind of barriers and issues that have to be resolved. So for example, there's this whole issue of having to think about how to protect any attorneys who offer something like a 1-hour consultation on a pro bono basis, how to protect them from malpractice, then also how to really apply a means test to us if we want to use a sliding scale. So I touched base with him recently to ask for the status of these two work, and he says it's ongoing, but he feels that he's pretty close to coming back to staff and saying, okay, this is my conclusion on what we can do with this. So I think that maybe for now we can just, I would recommend that we just plan for at the next meeting, we will come back, maybe I'll invite Professor Robertson to come back and just really share his conclusions about this work and how feasible it is. Okay, how's that sound? Okay, great. Okay, so now I'm going to turn it over to Justin to talk about something different, which is the idea of the State Bar Court developing self-help materials. This is something that Professor Robertson, he recommended all these potential reforms, and then this kind of started on a separate track. I don't know if we found out that, I forget if we found out that it was like someone was interested in this, and then when Professor Robertson made his response or made his recommendations, or it was in response to his recommendations. But in any case, Justin's here to share what he's learned. Go ahead, Justin.
I'm going to quickly turn, you can take down the PowerPoint. I'm going to quickly turn it over to Judge McGill. We talked about briefly that some of the self-assessment materials that are going to the Board of Trustees in July that will kind of help those solo practitioners and those attorneys that may need that assistance. And then another area where the State Bar Court has taken a lead is in developing some self-help materials. In the effectiveness subcommittee, Judge Wang is a member of that subcommittee, and she informed the subcommittee that in ENECs, some of the entries of the first ENEC, she spends time educating those attorneys that are unrepresented. And so the development of self-help materials is definitely been a focus. And so Judge McGill, if you wouldn't mind telling the committee about those development, where they're at and when we can expect those materials. Oh.
I forgot to unmute myself. Yes, Justin, I'm happy to make some comments briefly on this. So back in March, I went to the Bridging the Gap working group headed up by Sean, if I recall correctly. And we presented an idea of developing a self-help guide to sort of bridge the gap from people who are representing themselves and have very little information about how the discipline process works, our court's kind of unique way of doing things, and versus somebody who has representation from experienced counsel. So starting in March, we began this, and first we surveyed, our court staff went out and surveyed what other states are doing and took a look at what they did and sort of coming up with our own path. So at this point, we have drafted a guide that is going to, right now it's about 30 pages. I think it's going to wind up being about 35 when it's all done, and provide a fairly good overview of the discipline process and each step along the way and the types of different cases. And within those, sort of what the court looks at for ways of proving these various actions, also defenses, and also how aggravation and mitigation evidence works, so that attorneys who are unrepresented have an opportunity to know in a more clear sort of vernacular way of speaking about how they can go about gathering evidence to basically present the best defense possible. So at the end, the goal is that when someone comes out of the disciplinary process, whether they get a dismissal of charges, minor discipline, major discipline, I think it's fair to say no one's ever happy with getting a discipline from the state bar court or the Supreme Court, but at least they feel like they've been treated fairly and they haven't felt like OCTC's been having some sort of drastic informational advantage, sort of like asymmetric warfare. And they've just been, kind of sitting without knowing what to do. A lot of times attorneys come in, and I definitely recall this when I was a trial judge, even well-seasoned attorneys kind of come in if they just, they don't have the ability, the financial wherewithal to hire an attorney. They're kind of like the deer in the headlights. And of course it's because they're representing themselves and the emotional turmoil that comes with all that. So we're hoping that this guide is comprehensive enough to give the attorneys some feeling that the informational advantage has been leveled between OCTC and the impro per attorney who's going through the process. So we anticipate having the draft done sometime in September and bringing it back to the working group, and also soliciting comments from OCTC, OGC, and from other members of the public, so that we have a really good comprehensive guide that people feel like is actually giving some good information to those attorneys who are going to represent themselves.
Thank you, Judge McGill. So this information will be presented to the larger ad hoc commission, right? And not this fairness subcommittee, is that correct?
I would anticipate so, yeah.
Okay.
Yeah, the release of it will be, like I said, in September. Probably will first bring it back to the Bridging the Gap working group, where we kind of brought this, where it kind of began. And then also, then soliciting other comments and also bringing it to the ad hoc commission. I do want to see as much input from people as possible. Always, I prefer more input than less input, because it's a pretty good, I think it'll be a very helpful document in the end.
Thank you. Okay. Any further questions, comments, Judge McGill? Okay, I kind of wanted to circle back to removing discipline that's on the State Bar website. I know there was some discussion about removing low-level discipline. I don't know if this subcommittee would like our working group to possibly explore or research further removing not only low-level discipline, but maybe, I don't know, other levels of discipline. I think Melanie had kind of given us a brief overview of exactly what qualifies as low-level discipline. Is there like mid-discipline, or is it like a higher level? I don't know. But I know we had some discussion regarding consumer alerts. Judge McGill had a question about that. So I didn't know if the subcommittee had wanted more information on, you know, how consumer alerts are posted to our website, or.
Yeah, I'll bring back a more comprehensive description of consumer alerts, what is and isn't on the website at the next meeting, and vet that with the working group.
Okay. Any further discussion on removing discipline from the website from any of our members? I know we're kind of jumping around on the agenda. Justin.
It's okay. And
okay.
The reason we brought this discussion of Professor Robertson's recommendations and also what the State Bar is currently doing in self-help materials is to see if there are other areas that the subcommittee thinks that the bar should be focused on. This is kind of what we're doing, what we're exploring, but if there are other areas that the subcommittee thinks that are worth exploration or should be focused on, this is what we're kind of soliciting input for.
Should we put up that list of questions that we had earlier, Justin?
Yeah, I can. Can you see the screen?
Okay.
So I think we've covered a lot of these questions. I don't know. The working group's going to really dive into, you know, the last question. And then once we get through the costs that I will give a short presentation on, I will turn it over to Judge McGill for his appearance of State Bar Court independence discussion.
Sounds good. Thank you.
Okay. So we can move on now to the costs. So Lisa, if you can start the PowerPoint. And so last time I brought you the discipline system costs, and there were some questions about the costs. So I wanted to provide a little bit more in-depth analysis on the different costs. And so there are two different types of costs. There are the discipline system fees, and these are mandated through Business and Professions Code. The State Bar shall include the recovery costs when an order of discipline is issued. And these fees are trying to recoup the cost of discipline. You can go to the next slide. So these are the fees. We brought these to you last time. There was some discussion that it jumps up significantly once you get to a multi-day trial and to the review department. But these are the fees that the discipline system imposes by statute. So if you go to the next slide, these were as of a discipline study in 2010. It was a time study of State Bar Court and OCTC on what it costs to implement the discipline. Excluded from this were judges and attorneys' fees, but a support staff was included, and they did basically a time study on each individual process that they did. They marked the time, and then they put a cost for that time. And so they did a very in-depth study as to develop this costing model. Since this was the second time they had done this study, and the two previous time, or the third time, and the two previous times, the support cost or the discipline cost increased by 40% each time. In this cost model, they had the discipline cost tied to inflation, so the CPI and consumer price index. And so every year these discipline costs go up with inflation. It's anywhere from 2 to 4%. And so that's where the 2021 costs that I previously showed you have been going up continuously since 2010. There hasn't been a new cost study. This is just the 2010 model with inflation. To give you an idea of the amount of money that is collected from these costs, we collected $1.2 million in 2020 of these costs. And if you combine the State Bar Court and OCTC budget, that is $75 million. So these costs make up about 1.4% of the total of those two budgets. And so it's to recoup fees, but it does a very minimal amount of recouping fees. And I talk about this because at the last subcommittee meeting, I talked about the trend of getting rid of administrative and criminal court costs. California was the first state in the nation to abolish, I think it was 23 different costs for probation monitoring or development of an investigation report, or all sorts of these fees were eliminated. And so this is how the state bar collects its fees. If this subcommittee decided that they want to reevaluate the fees or not collect fees, it would require a statute change, but that is a recommendation that this subcommittee could also take a look at. The next page. Sanctions. Sanctions were passed by statute in 1994, but it only came in 2020 where the guidelines to implement the sanctions were actually issued from the Supreme Court. And these sanctions are on high-level discipline cases. So they involve disbarment, they involve suspension, or resignation with charges pending. And what the sanctions do is for each violation, so in a disbarment case, for every violation, you can go up to $5,000 with a cap of $50,000 for the total. And for suspensions, it's $2,500, and that the guidelines are $2,500 and $1,000 for resignation with charges pending. And these are above and beyond restitution and the discipline system fees. And as that first bullet says, all of this money collected goes towards the Client Security Fund. And the Client Security Fund is the fund that reimburses people who have been wronged and had their money taken from them by dishonest attorneys. And so the sanctions is a way to kind of reimburse the public an additional amount and of funds. You can go to the next slide. So I bring this up in saying that a lot of the other states that have kind of moved away from criminal court costs is because those costs in Ferguson and other places were meant to fund their government, fund their operations. The State Bar Court's discipline system fees are a minor part of its overall budget and minor part of its revenue. And so I wanted to point that out. And then I kind of open it up to the subcommittee if they have any questions, or if this is an area where they would like to, reevaluate whether or not the state bar continues having the discipline system costs as they are.
Well, from my understanding, it was an access to representation issue, right? Some attorneys don't have $15,000, $20,000 waiting, laying around to hire counsel to represent them in state bar court when matters such as these arise.
Right, and I should clarify that these costs are due with your attorney dues. So if you have discipline, say it goes all the way to the review department and you have that $22,000 cost, they are due the next time you pay your attorney dues, but there is a mechanism in place that'll allow you to defer those costs over several years, 3 or 5 years. And so it won't prevent you from continue practicing if you are on that payment plan.
Got you. Thank you. Okay, I see a few hands raised. Judge McGill?
Yeah, thank you, Shanae. So first of all, if you recall also, and Justin, I can't remember how you brought it up, but I think you did, that the cost in California, the assignment of cost, are quite large compared to other states in the United States. In fact, I asked my staff and we tried to do a little research ourselves, and only one other state came somewhat in the same neighborhood, still much lower than what California does, but by far, most states charge something in the range of $1,000 to $4,000 for the whole thing from start to finish. And a lot of it is connected to direct cost, because in these other systems that don't have a professional court like California, they have basically special masters, a panel of 3 or even 1, and they travel around the state going to where the attorneys are to do these hearings, it looks like. And a lot of those requirements to collect those costs are basically to reimburse that particular state bar for the cost of sending those people out to those locations. So you have to understand just from the very beginning, I think, that California has just a whole different paradigm of what we used costs for. I think it probably came out of budget crises back in the 90s, where people, a lot of user fees were being implemented where they hadn't been implemented before. So, but California really is an outlier here in the United States in the type of costs that are assessed.
Thank you, Judge McGill. Melanie, and then Mr. Larkin.
So to the question of whether or not we ought to look more closely at the cost issue, I think we should. Also for the reasons that Judge McGill said, I think that they're quite high. I don't necessarily think that that means we shouldn't have any costs, but I don't know really what it looks like. I also would like us to look at the issue of sanctions, frankly. They are newer in terms of rules that have been enacted to actually impose sanctions. We haven't done it for years. We hadn't done it for years up until the time that the rules were promulgated. It's been quite contentious. I don't think that there are many other jurisdictions, if any, that impose sanctions. That doesn't necessarily mean that we shouldn't, but I just wonder what the purpose really is. And if our collection of costs is as low as it is, I'm just not sure what our collection in sanctions is going to be. I don't even know if we know at this point how much we've collected in sanctions, but it just seems like a piling on for no apparent good reason.
I agree with Melanie and Judge McGill. It just seems punitive to me. And the context of California leading the way in removing costs in other environments, it might be an opportunity. I also think getting back to the whole idea of being able to fund representation. I don't see Ed here right now, but I know early on the California Association of Respondents Council showed some interest in finding a mechanism to provide some reduced rate or free representation. There's a little bit of that in Illinois. Holland and Knight does that. Peter Jarvis and his team. It doesn't cover the need. I did see a NOBC listserv about some other program. I tried to track it down while I'm on this call. I can't find it. Some cut rate consultation program, which would go a long way to giving context to a lawyer who may not be able to afford a lawyer. And then I would add that, and I don't know if this is true in other states, but in our state, it is typical that insurers provide up to $50,000 in defense costs as part of a professional malpractice policy. We all know that the availability of counsel for those charged makes the cases go more smoothly from the perspective of the organization and the prosecution, but it leads to outcomes that, in my view, seem more fair. So just my 2 or 3 cents there.
Thank you, Mr. Larkin. Okay, I don't see any more hands raised. So the issue of sanctions, Justin, did you say that the sanctions, once collected, they fund the client security fund?
They go towards, they're deposited in the client security fund. It has its own $40 designation that every year each attorney pays into the client security fund. This is in addition to it. And it only, as Melanie mentioned, it only was instituted this year. So we would only have 6 months worth of data on it because it's very recently implemented. So we don't really have any size as to these costs.
Thank you. Does anyone have any comments, or I don't know, am I hearing from the group that we want to eliminate sanctions?
I personally think we should look into it a little bit further, and maybe we can come back with some options for the group to consider for a total elimination of fees and costs, and sanctions is a little bit separate, and then maybe some graduated proposals. We could work with staff and bring them back.
Thank you, Leah. Sounds good. Justin, how are we on our agenda? Are we covering what we need to cover?
Yeah, we're right on time, and we can move into Judge McGill's presentation, and it was slated for about a length of time. So I think we're doing good.
Thank you. Judge McGill?
All right. Lisa, yeah, thank you. So this afternoon, I would like to take about 20 minutes and talk to you here about the State Bar Court, particularly independent and impartiality. Before I get started, again, I'm Judge McGill. I'm one of the review and appellate judges here in the State Bar Court, and I've been working in the review department since 2016, and I started as a judge here back in May 2015. And so in presenting this topic today, I want to cover 3 areas. And just first, to give some historical perspective and to discuss what happened before the formation of the State Bar Court in 1989, how the process worked, and then talk a little bit about the State Bar Court itself, the composition and organization of it, because many of you might had not been aware that we had a State Bar Court. Quite frankly, I wasn't even really aware of the State Bar Court until about probably 5 or 6 years before I was appointed to the court. So it's something that, of course, people don't give much thought to when you're not being disciplined. You only become aware of it when you are facing it. So I think it was a good opportunity to sort of talk about who we are, how we're organized, and what we do, and then a short discussion about the adjudication process that happens here at the State Bar Court. And then finally, to talk about what I would label as special challenges that the State Bar Court has regarding the issues of independence and impartiality. My hope is that this issue becomes part of the work of one of our focus groups down the road. So next slide, Lisa. So prior to 1989, what did the State Bar do regarding discipline? And it was a volunteer system. It was conducted generally by 3-person hearing panels with a mandatory review of those cases by an 18-person review department panel. And there were 350 volunteer referees that worked on these hearing panels up in the mid 80s and late 80s towards the end of this process. So it was quite a lot of scheduling and basically making sure everybody knew where to be and when. So in the late 80s, there was a motivation that came for a full-time professional State Bar Court. And at the time, it still is in many ways, we're still the nation's only full-time professional trial and appellate bar court. We, in, I think, Arizona and Colorado, a few years ago in each state, they began having a hearing judge to handle creating the record for discipline cases and making an initial recommendation to their respective state Supreme Courts. There are a couple of other states, I believe Rhode Island, and I think even the state of Washington is currently considering instituting hearing judges to professionalize that aspect of their discipline systems. But we're the only state in the nation that has at least a full-time appellate department to review cases before they're forwarded on to the state Supreme Court for consideration. But what motivated the creation in 1989 of the court is that first there was a backlog of cases in the hearing department, which took more than one day due to scheduling issues with the volunteers that were hearing cases. So if a case was done in one day, that was pretty much easy. There was no difficulty there. But if there were multi-day cases, then of course you had the three attorneys on the hearing panel and you had the respondent. And if that respondent had an attorney, then you had at the time they were called examiners instead of prosecutors. And all these people would have to coordinate any subsequent hearing days. And so as a result, the backlog started growing on those multi-case days. So the legislature became very, very concerned about it. Just to let you know, with the new system, at least for the last couple of years, the State Bar Court has been maintaining pretty well its goal of clearing cases timely. The hearing department has about a 90% timely clearance rate, and the review department almost always has a timely clearance rate. So there really is no backlog anymore regarding the cases that go through the State Bar Court system. But that was what the legislature was concerned on, is regarding the issue of backlog. From the Supreme Court's point of view, it's been told to us by at least one retired Supreme Court justice that it was an increasing workload of the Supreme Court in reviewing cases in general. Their docket was growing in all sorts of different types of cases in the mid to late 80s. And at one point, it looked as if the State Bar discipline cases were occupying up to 25% of the Supreme Court's docket. So the Supreme Court was having a problem in managing its caseload efficiently. So that's another reason why the professional State Bar Court came around. So next slide, please. So the composition of the State Bar Court currently is we have 5 hearing department judges, 2 in San Francisco, and that would be Judge Wang and Judge Chawla, and 3 in LA, and that's Judge Valenzuela, Judge Saab, and Judge Rowland. And they are appointed by various entities I listed here. The Supreme Court appoints 2 of them, 1 each by the governor, the Speaker of the Assembly, and the California Senate Rules Committee. And the review department for appeals, I am one of 2 review judges. My colleague Richard Hahn is the other review judge, and then we have our presiding judge, Catherine Purcell. And all 3 of our appointments are made by the Supreme Court. So one of the things that we run into quite a bit is people's perceptions that we as judges are employees of the State Bar, and that is just not correct. And we work on this more often than what we thought we would have to. But many people seem to believe that we are employees, and we actually aren't. So not only are we hired by appointing authorities who are not in the State Bar, the discipline or removal of a State Bar Court judge is not by the State Bar itself, but is pursuant to the Business and Professions Code section 6079.1A, and also by the California Rule of Court 9.11D, and ultimately the final decider on whether or not a judge should be disciplined or removed is by the California Supreme Court itself. So I'm going to go to the next slide. So the authority to act. The State Bar Court is essentially the administrative arm of the California Supreme Court in the discipline and reinstatement of attorneys. The Supreme Court always retains its inherent power to discipline attorneys. And for those of you who want to delve into that, I provided a case site for you, and also Business and Profession Code site sections in the Rule of Court that pertain to how the authority of the Supreme Court and of the Board of Trustees is transferred to State Bar Court in order to do certain actions, and how it operates. So what we can do as judges at the State Bar Court, we have the power to order dismissal of formal charges or issue approvals, both private and public. For greater discipline, so that would be starting with suspension, no actual suspension, but probation, going all the way up through disbarment. What the State Bar Court actually does is we make recommendations to the Supreme Court to consider in making its final orders on those discipline outcomes. Now, we really haven't had a Supreme Court decision that changed a state bar court recommendation on discipline really since 2012 in a case called In the Matter of Glass, and that wasn't even a discipline, that was on a mission on moral character. But I'm quite proud to say that the Supreme Court really takes all our recommendations, probably over 99% of them, and implements them. They do return items to us on occasion for us to develop the record on a particular question they think has not been fully answered. But for the most part, the State Bar Court does take our recommendations and make them final recommendations, final orders on discipline based on our recommendations. So next slide. What we do in the adjudication process, and I know I don't have these up on the slide, but we have talked about earlier regarding the early neutral evaluation conferences. So I won't go into that, but the process really starts with OCTC filing a notice of discipline charges, or in conviction cases, it's called a notice of transmittal of the criminal record, and that's sort of how the process begins. What happens is that first a record is created with relevant and reliable evidence pursuant to State Bar Court Rule of Procedure 5.104. And that is not using the technical rules of evidence. We do, for example, allow hearsay evidence in. We basically look at whether or not evidence is relevant and reliable, the type of evidence that people would rely on in the normal conduct of affairs. So we have a much more broader rule of admissibility on evidence that would happen in, for example, Superior Court. The burden of proof is different than most Superior Court cases. We use a clear and convincing evidentiary standard that is much higher than the preponderance of evidence standard used in most civil cases. It is lower than that used in criminal court, which is beyond a reasonable doubt, but it is a fairly high standard. And people ask us why we have such a high standard. And basically what's going on here is that the license and practice law is a property interest, very valuable property interest. So that property interest shouldn't be taken away unless we are fairly well convinced that the evidence points to culpability on any one of the charges. On culpability, what we do is we make findings of fact and conclusions of law. We also then look at aggravation evidence provided by OCTC and also mitigation evidence offered by the respondents, and to determine what is the appropriate level of discipline in a case. Where we find culpability, we apply the standards for attorney sanctions for professional misconduct. Those have been issued by the Board of Trustees. And the Supreme Court has stated that while the standards are not binding on the State Bar Court, they are, however, entitled to great weight, and they should be followed whenever possible. And we do that. And if we decide to go outside the standards, and almost all the times we're looking at going below what the standards are recommending on discipline, the Supreme Court has asked us to provide a good explanation, because the Supreme Court's general philosophy has been they want to follow recommendations made by the State Bar Court unless the case law basically cites to, unless there is grave concern regarding the appropriateness of the discipline being recommended. Finally, for cases that are reviewed, when they come to the review department, unlike how appellate courts generally work, we actually do a de novo review of the record. So we look at what the hearing judges have said and stated and found regarding the case, credibility, findings of fact, etc. But we are not necessarily bound to follow them. We can make our own different findings from that of the hearing department. So that's a little bit more liberal standard than what would happen in the typical appellate case. Next slide. And then finally, we do manage other processes here. Again, the early neutral evaluation conference, which has been discussed before, along with the voluntary settlement conference, which occurs during the pretrial phase before trial begins at the State Bar Court. Both of those are usually heard by the same judge, and also a judge who's not going to wind up being the trial judge in the matter. And then we also manage the alternative discipline program, which I think we've already discussed a little bit earlier, either as the commission or as the subcommittee. So next slide. So really to the main point of why I'm here today to talk about is the challenges regarding independence and impartiality. It's an important point that has been something that judges have reflected on for quite a bit of time here at the State Bar Court. And in fact, in discussions with the Chief Justice herself, she has remarked to us in prior meetings that she sees this as a paramount factor in the court's operations. And first, I'd like to introduce you to a Rule 1015A, which is no state bar entity, officer, employee, or agent shall interfere with the adjudicatory independence of the State Bar Court to hear and decide the matters submitted to it fairly, correctly, and efficiently. So next slide. So really, we have two areas of concern. First is areas of concern identified by the attorneys and in the public. And in fact, some of these comments come from even as recently as last year, when Judge Brenda Harbin Forte, in written public comments to the Board of Trustees, made concerns, expressed her concerns regarding the independence and impartiality of the State Bar Court because of its relationship with the State Bar. So some of the things that we've heard is either in hearings or actually even in the review department, respondents saying that we are a captive court because we as judges operate out of the State Bar buildings. We work glove in hand with the State Bar. We are all on the same team. It's actually been expressed to us on times. And it's a bit shocking to have to respond to that in an open court session when a respondent says that. However, there are some indicia that really do lead somebody who isn't intimately familiar with the process to come to those kind of conclusions. And for example, at least here in the LA courtrooms, the State Bar logo is up on the courtroom wall that is behind us when we are in session. Not only that, our staff emails, our emails are used, the end part of the email is at statebarcourt.com, but for staff emails, they are calbar.ca.gov. So if someone is a respondent or someone from the public is interacting with a member of the staff, they're addressing to an email address that identifies the State Bar. We've often heard from people that we are in cahoots with OCTC and the State Bar because State Bar judges are paid and benefits are provided by the State Bar. Now that is pursuant to state statute, so we don't really have any way to respond to that. But it is one of those indicia that come along where people from the outside say, based on all these different things, we don't know if we can really trust that the State Bar is trying to be independent, even though I think OCTC would probably agree that because of the decisions we issue on occasion, we do act independently. But again, it's what people from the outside see in. And in addition to all that, we have our own concerns here as State Bar judges. And what I first want to point out is Rule 1016 on this point, which states that the State Bar shall provide adequate staff and facilities to support the adjudicatory functions of the State Bar Court. And I think that the State Bar does a fine job. We have good access to resources in order to fulfill our duties as judges. However, it becomes at certain times the interactions that we are required to have with other parts of the State Bar give State Bar Court judges some concerns. And I think the best way to illustrate this is by an example. So State Bar Court judges are required to use the Office of General Counsel for work-related legal advice. We've been told time and time again that OGC is our attorney. But when the state bar wants to appeal a decision by the review department to the Supreme Court, OGC represents the Board of Trustees and the state departments and the state bar in these particular appeals. Well, when they do that, they're basically inherently criticizing the review department, who is also supposed to be OGC's client and when it comes to other legal matters. So it becomes it's not a classic violation of the rule of professional conduct 1.7 regarding conflicts, but it does have bad optics from our point of view, that when someone looking on the outside that's looking in, they see an interaction, working with the state bar court with other parts of the state bar that can lead people to feel that we're just not being independent or impartial. And in fact, it leaves us feeling very uncomfortable, because really what's guiding us and our concerns here is the Code of Judicial Ethics. If you look at Canon 2 of the Code of Judicial Ethics, judges are required to avoid any improprieties, or more particularly, the appearance of any improprieties. And it's really the appearance issue that gets us concerned, whether it be concerns that the attorneys and the public have identified, or those that we as judges have kind of identified for ourselves, that we want to make sure that the only way to maintain independence and impartiality is to avoid any appearance where we look like we are interacting with the state bar in a way that makes our position less secure with the public, that we are being impartial and independent. So that's really the conclusion of my presentation. I would like to say, just as a final caveat, I certainly don't have any critique about any time I've interacted with OGC. I think OGC attorneys have done an excellent job in trying to do what they've been asked to do and providing us legal advice from time to time. I think they strive to do as good a job as possible. So it's not a critique about the individual attorneys in the office. It is really the overall organizational interplay between the state bar court, mainly OGC, also other areas of the state bar that we have to interact in. So with that, I'll be happy to entertain any questions.
Thank you, Judge McGill. Melanie, you have your hand raised?
Yeah, thanks.
And Leah?
I think a comment and a question. So I appreciate the concerns that you're raising, Judge McGill, and I can see the challenge with perception. I have to think it's largely because the state bar court is paid by the state bar. I mean, that's the most obvious connection to me. I'm wondering if there's been any inquiry into other models, what other jurisdictions do, if there's a way to somehow, literally disconnect the state bar court from the bar, and maybe have it answer more directly to the Supreme Court. I know you answered to the Supreme Court, as do we, but I think that perhaps other jurisdictions literally do that rather than being associated with the bar as a whole. So I'm wondering if there's been any look at other jurisdictions and how they do it to try and maybe model something.
Well, again, there's very little comparison that we can look to. We could look at how Arizona and Colorado how they manage and pay for those hearing judges that do that. But I think right now, those are the only two states that have any other approach. I know, I would assume with the other discipline systems that rely on volunteers, that would be something provided by the state bar. Maybe Jerry can chime in on that from his experience in Illinois. But there are also some states where the discipline is actually done by the judges, Superior Court judges themselves. I mean, Texas and I think New York come to mind, where the discipline is actually discipline hearings and such, I think, are actually handled by the courts of record in that state. So it's all kind of a mishmash, really, in a way. But Jerry, if you have any observations about your own state system?
I think the appearance issue exists in most states, and I've always admired California's professionalization of the adjudication function. I think in Florida and New York, it might be that the courts appoint masters or retired judges to hear the cases. New Jersey has a really strong review board, but I think it's part of the agency. I think Michigan might have a separate entity for adjudication, separate and apart from the grievance administrator / prosecutor, and that reports separately to the court, although they're all funded by the mandatory state bar's revenue stream. So there's so many different models, but I think Melanie is right. If this is really an issue, the court could, with legislative involvement in California, carve out your funding separately, have a different office than the state bar office, or a different floor with different indicia. We certainly make every effort to separate out in Illinois, our adjudication departments and personnel, but by internal organization structure and not having signage that would create the issue that you're having, but I don't think it's anywhere near as well designed as your system.
Right. And of course, on top of all this is just because, California is just so, so many attorneys in the state. I mean, really, when you look at the numbers published by the American Bar Association, oddly enough, California is not #1 in the number of attorneys in the nation. New York is actually #1. But after New York and California, by far, the number of attorneys dropped precipitously to like something like 1/3 of the number for #3, and it goes all the way down to just maybe 1,500 in some of the less popular states like Wyoming. So a lot of this is also the issue of just how to handle the volume of attorneys and discipline complaints that come in and how to handle those.
Judge,
Just kind of a side note.
Clearly the largest, I'm going to call it unified regulatory system for lawyers. New York has balkanized decisions in districts or whatever they call their entities. So they're somewhat separate, and they go up to different reviewing courts. So clearly the largest in terms of the organization supporting number of lawyers.
Right. But in the end, I would like to have this topic as an aspect of a working group to try to wade in and try to see what can be done in any number of ways, whether or not they be dramatic or even granular, in a way of trying to buttress the idea that the judges are independent and impartial. I think people within the system, I think Melanie and Steve would agree with me, we are independent and impartial. I don't think anybody within the system disputes that, but that's not the end of the discussion. It's a discussion of what the public perceives, not only just the attorneys, but the public in general perceive as to what is actually in their mind impartial and independent.
Thank you, Judge McGill. Leah, you had your hand raised.
Yeah, I lowered it because I think my question was somewhat akin to Melanie's, just asking Judge McGill what his ideas would be for how to rectify this concern. So
I don't know. It's a big one. I think that, for example, one idea out of the box would be that perhaps we have a separate line item in the state bar budget so that the judges would be looking to outside counsel for legal advice rather than relying on OGC. So you kind of remove that interaction where OGC has been our attorney on occasion. And it's significant because we do get sued more often than what people think. And at that point, and OGC steps in, and OGC does a fine job in what they're doing. I have no critique on what they do. But the whole issue is, again, they have to be our attorney, but then they're acting on behalf of the board of trustees or in their relationship with appeals to the state bar or other issues vis-a-vis the state bar court. And that's where the difficulty resides. But I mean, one idea is simply providing us the opportunity to get outside counsel to advise us and represent us.
Thank you, Judge McGill. So do you want us as a subcommittee to, I don't know, bring back more information, or excuse me, have bar office staff bring back more information or do further research? Or do you want us as a subcommittee to make a recommendation to the larger ad hoc commission?
I don't know if we're at the point of making a recommendation or not, because this is sort of a new topic that we really haven't brought up before. I don't know if you want to have, I mean, my understanding was, I thought maybe down the road, the commission be broken into working groups to address certain issues. And maybe that's something that could be one of those working groups. I'm not looking for a solution today, because I fully understand it. And I know staff has to do its work in looking at proposals and analyzing them and seeing all sorts of things that even I as a judge don't necessarily see. I mean, I don't have the full repository of information either. So whatever we think is best, and whatever the group thinks is best, I'm willing to think it's a good idea.
Thank you, Judge McGill. Leah, do you think it's appropriate to, or for this subcommittee, I don't know, to form a working group to kind of explore this issue further, or?
Sure. Yeah, I think if
Or what do you think?
If that's the will of the subcommittee, then I would say yes. It's a big issue. It seems a little bit like the solutions maybe a little bit like inside baseball-y for this group, but I'm not sure of that. So I don't know. I think maybe turn it over to your members and see if this is something that they want to explore further. That probably would be a good idea.
Any further? Thank you, Leah. Any comments or questions? Mr. Salik, yes.
Yeah, I think I kind of agree with Leah's reaction that this is, sometimes you use the term wonky. I think it's a wonky inside baseball sort of thing, the issue about OGC that Judge McGill has raised. I think what would make the most sense is maybe for the board leadership to think about this and communicate with the State Bar Court and look into it. I'm not sure it's really suitable for the committee to consider, at least. So I would at least postpone it for now and we can look at it internally.
Thank you. Okay, Justin, where are we on our agenda? Well, we're past time. It's 2:15.
Right. We've accomplished the agenda. I apologize. These are trying to get everything in the 4 hours. We went a little over, but I know everybody's time is valuable. But I will share the last screen real quick just to recap so everybody walks away on the same page. What I have here is on the addressing racial disparities in the discipline system. These are things that people talked about. Mandatory training potentially for anyone with a client trust account, targeted outreach. Steve Moab kind of talked about how they're looking into that and should be sending out materials soon. And then we've established a working group. I don't have all the details of the working group, but I do have it in my notes that we're going to bring back to the subcommittee. And then for the attorney's cost and fees, we're going to explore the reduction or elimination of discipline fees and sanctions, kind of look at other jurisdictions more, bring back something substantive that the committee can make recommendations on. And then State Bar Court independence, it looks like it's tabled for now because it's an inside baseball, but there'll probably be a follow-up at a future meeting on that.
Thank you. And do we have any idea of when our public members will join the subcommittee? Because I'm thinking that we probably should have a meeting to kind of bring them up to speed. And then I know.
Yeah, I reached out to our communications department to see if we had any new members during this meeting, and we don't as of now. I know they're actively recruiting those members, and as soon as those members are on board, I plan to meet with them as a group to try and bring them up to speed, because it's not realistic to have them watch, 40 hours of committee meetings. Nobody has that time, but I will definitely bring them up to speed on all the topics that we covered, and then especially where we've kind of tabled the discussion and want that public input, I will especially focus on those areas.
Thank you. Does the subcommittee as a whole think that we need another meeting? I know our next meeting is scheduled for August the 24th. And I think at that meeting, Leah, correct me if I'm wrong, Justin, correct me if I'm wrong, are we supposed to be drafting recommendations or will, because we still obviously want some more research on some issues. So I'm just kind of trying to figure out the timeline for making our recommendation.
Yeah, I think, oh, go ahead, Justin. I would just say quickly, I think the idea is that the subcommittees will be bringing forward preliminary recommendations to the full commission for its September meeting. But I think at that September meeting, we may very well create new subcommittees. And I think Judge McGill kind of alluded to this also, without us having coordinated, on particular topics that the commission, from both subcommittees, that the commission wants to dig into deeply, right? To develop the final ultimate recommendations that the commission will vote on. So right now we're broken up into fairness and effectiveness. I imagine after the September meeting, we may have a subcommittee all on post-conviction expungement, for example, or prevention, some of these thematic topics that are actually, frankly, coming up in both subcommittees. So I think that's my vision. I don't know, Justin, if you want to jump in.
I think you stated it perfectly. So that's the idea, is that we may not have every recommendation fleshed out, but we can find the focus areas and then go into working groups to get into the details, the inside baseball details.
Okay, sounds good. So it sounds like we don't have to meet beyond the August 24th date. Okay, just wanted to be clear. Well, thank you all for coming today or joining on Zoom to discuss this very important issue. A lot of work still to be done. And thank you all for your input. Justin, am I missing anything?
I don't believe so.
Okay, so I'll see you at the August 24th meeting. I believe that's on a Tuesday, so we won't have any more Monday meetings. So thank you all for your time. Enjoy the rest of your day. It's 2:30. Meeting is adjourned. Thank you.